If I don't do nothing else, I'm gonna talk to law. Let's talk about it. But before I begin, can't get my words out. For those who may not know me, I'm a Texas trial attorney. Y'all see the law license on the wall, signed by the 9 justices of the Supreme Court. I was minding my business. I was drinking my water. And somebody said, we got to talk about Melly and his attorney. Y'all know the last time we was here, we watched the video, and I said I would get my hands on the lawsuit. Melly filed a lawsuit against the sheriff's department, and the sheriff's department responded. The sheriff's department, sheriff's office, whatever you want to call it, it said, no. You're not going to talk about us, and we're not going to talk about you back. So I said, let me get on here and just cover this a little bit so we can go through the lawsuit. What's going on, Mr. Bernadette? What's going on? Oh man, I'm going to miss this live. I'll catch the replay. Oh, thank you for popping in whenever you see this. Thank you. What's going on, Mr. Bruce in the building? What's going on, Tips Tate? What's going on, Miss Susan? Fit at 57. Happy Friday. Happy Friday. So we're gonna cover this Melly. I mean, it's crazy. I kind of skimmed through Melly's lawsuit, and I kind of skimmed through the reply, and it's insane. What's going on in Broward County? And for those who may not know, Melly is a popular musical artist who had a famous song, and I had got permission to play it, so I'm gonna play it for y'all so the people who will see this video later will know who we talking about, who is Melly. So we're gonna play that for a little bit, and then we'll jump right into the lawsuit so we can see what's really going on. Let me see if I can get this thing to play. Let me know if y'all can hear it. Y'all hear this in the comments?
Probably say that I'm tripping when I'm all alone in my jail cell. I tend to get in my feelings, and all I smoke is that loud. Don't pass me no midget, and I'ma smoke all of my pain away, cause that's the only thing that gon' heal it. I don't understand you women who go around pretending as if they really fuck with me, so I love them all from a distance. Cause the same bitch say she down the ride, be the main one who tricking. Got my limits with promethazine, cause every time I wake up in the morning, I got murder on my mind. AK-47s, Mac 11s, Glocks and 9s, and all these pussy niggas hating, trying to knock me off my grind. But I can't let them do it, I got murder on my mind, bitch, I got murder on my mind. Bitch, I got murder on my mind. 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 Yellow tape around his body, it's a fucking homicide. His face is on a t-shirt and his family's traumatized. I didn't even mean to shoot him, he just caught me by surprise. I reloaded my pistol, cocked it back and shot him twice. His body dropped down to the floor and he had teardrops in his eyes. He grabbed me by my hands and said he was afraid to die. I told him it's too late, my friend, it's time to say goodbye. And he died inside my arms, blood all on my shirt. Wake up in the morning, I got murder on my mind. AK-47s, Mac 11s, Glocks and 9s, and all these pussy niggas hating, trying to knock me off my grind. But I can't let them do it, I got murder on my mind, bitch, I got murder on my mind. I got murder.
All right, so y'all get the gist of it. It's a catchy song, and some people were saying that he made that song after the fact that it happened to his friends, but some were saying the song was made way before that, the previous year, before his friends were even um, killed in that vehicle or shot in the vehicle. Uh, let's see. Oh, what's going on, Monica B? Oh, he had federal court today. Okay, and he probably had federal court in regards to this particular lawsuit that he filed. Oh yeah, thank you. I don't mind hitting the like button. I haven't seen it yet. I've been working. Okay. Yeah, so we're just gonna go through it a little bit and let me see if y'all, it might be too big. Okay, so Jamel Demons is Melly, and he's suing Gregory Tony, who is the sheriff of Broward County, and it looks like in his personal capacity and in his capacity as the sheriff of that county, the elected sheriff. And for those who don't know, let's put our characters in place so we can kind of know who we're talking about. And this is the sheriff, Gregory Tony. And when he was a teenager, the sheriff of Broward County, apparently he got into a situation with another 18-year-old, I believe. And it was described as a self-defense situation where the sheriff killed the other teenager, 18-year-old. So, if it was self-defense, it was self-defense. They both were young at the time, but they said he lied on his police application when he applied. Even though it was self-defense, you weren't convicted. It was a policy that you still had to disclose it, and they said he failed to disclose it. They also said that he failed to disclose that his driver's license was suspended. And throughout the time his driver's license was suspended, he never disclosed that as well. And obviously, if you're going to be the sheriff, you want to make sure you have a character trait of truthfulness. And the reason I'm saying this, because when we read these lawsuits and these responses, we got to remember that it starts at the top. And, when you got the ethics commission saying that, the sheriff is a shady character, thank you, Tiff, then, hey, it's not a good look. It's not a good look. And then somebody said he looks like one of them. Come on. He kind of do. He kind of do. And then for the other person, this is the elected district attorney of that county. And we know this county is seeking the death penalty for Melly, which is crazy because his first trial, 9 of the jurors thought he was guilty of only manslaughter. And when I say only manslaughter, I mean it's lesser than first degree, capital murder. And 3 of the jurors thought he was not guilty altogether. So that means you have some people, or at least 12 in your county, that thinks that he didn't commit capital murder. So I don't even think the death penalty should even still be on the table. But this was on the table, and this trial was going on even before this DA came into office. But I don't understand why he don't come in and look at the case himself. Maybe he just left it alone. We do know the governor in Florida has a lot of power. The governor of Florida will kick a prosecutor out of office if they're not following, quote unquote, the law. If they're not doing their duty, he will remove you from office with a stroke of his pen. So, I'm sure he don't want that to happen to him like it happened to other prosecutors in Florida. So he's staying away from that. But let's jump back over. And also, before I get to the lawsuit, the death penalty normally had to be 12 people had to convict Melly and 12 people had to vote yes for the death penalty. But it was a trial that happened in Broward County by coincidence, where it was a school shooter. One person didn't vote for the death penalty. So the individual got to avoid the death penalty, and the state of Florida was upset. So they knocked the threshold down. Instead of needing 12 people to vote guilty, you only need, or for the death penalty, you only need 8 out of 12. And this is really bad for Melly, because had Melly case been over with a year ago, or when it first happened, a year after it happened, 2 years after it happened, 3 years after it happened, he wouldn't be facing this low threshold of the death penalty. So I'm sure there's going to be constitutional challenges to that. But it's crazy. Let's jump into this lawsuit, because this is what the real tea at. So Melly filed a petition, a writ of habeas corpus, and it's basically a writ to be released, produce the body, basically produce Melly in front of the federal court and show why he shouldn't be released. Y'all mistreat him in the jail. According to him, things are not going right. He can't visit his attorney. His attorney under investigation. They sent his attorney trying to break him out. All of this is in here. We got to go through it. What's going on, Ms. Deborah? See? Let's go. So Jamel Dennis is Melly, and buying through his undersigned counsel, and I'm gonna kind of skim, read this so we don't have to, go through each word for word. But they're asking the court to appear. They want the Broward County Sheriff to appear, Gregory, appear and show cause why Melly should not be immediately released from custody for egregious violations of the United States Constitution. And they say, you know why? In support thereof, petitioner, aka Melly, he states the following. The petitioner Melly seeks his immediate release because he is being illegally detained under conditions that violate the First, the Fifth, the Sixth, the Eighth, and the 14th Amendments to the United States Constitution. Not all of that. They violating all of that. Melly is a black male whose current detention conditions shock the conscience and could not even be imagined in this day and age, even in a third world country that has no guardrails protecting human decency and dignity. Oh, man. For over 3 years, Melly has not been permitted to make a single phone call or have a single visit with his family or any member of the outside world, including not seeing or speaking with his own mother in over 3 years. Come on now. Now, y'all know y'all wrong for that. Y'all don't want to let the man talk to his mama. Melly has and continues to be subjected to the type of debilitating isolation that renders his condition of incarceration cruel, unusual, and beyond belief in a civilized society governed by constitutional safeguards. He has also had restrictions placed by detention officials designed to impede his interactions with his attorneys and his ability to prepare for trial on capital murder charges. His cruel treatment by the Broward detention authorities warrants his immediate release from pretrial detention, since the detaining authorities have shown such a callous disregard for his human dignity, right to counsel. Man, what? And they go through and they list the parties. We know Melly's, he's been incarcerated at the Broward County Jail since February of 2019. And if somebody do the math, that'll be what? 7 years next month? Is that right? 7 years next month. And then you got the respondent, the person that's answering the lawsuit, Sheriff Gregory Tony. And they got the jurisdiction and in the background. Melly was arrested on February 13, 2019, and has been in continuous custody since that date. He proceeded to jury trial, but the judge declared a mistrial in July 21st, 2023, when the jury was not able to convict him. So yes, he had a trial for the people that waited 6 years. Okay. So what next month? So next month to make 6 years? Or 7 years? Wait, it's been, what year we in? 25? Oh, you're right. My bad. You're right. Yeah. You're right. Thank you for correcting that. It'll be 6 years, which is a long time. Yeah, that's insanity because he hasn't been convicted and he's still in jail on no bond. In October of 2023, Broward Circuit Court Judge John Murphy granted Melly's motion to disqualify the state prosecutor. In a motion contended the state attorney withheld evidence. So we had a prosecutor in this case. She was kicked off the case. Why? Because she withheld evidence. That's insanity. Don't that sound familiar? Don't that sound like a YSL case? Oh yeah, thank you. Yeah, it's been a long week. Yeah, thank you. And guess what? They brought in a new set of prosecutors, and they ain't no good. A new set of prosecutors have come on and have done everything in their power to delay the trial from commencing. They stalling. The case is currently stayed pending a ruling on an appeal taken by the state attorney. So they are appealing a ruling at the appeals court level. So even if they wanted to start the trial today, they can't because they're waiting for a ruling from the appellate court. But guess who's sitting in jail? Melly, who remains in custody since February 2019. He's continuously abused and denied bond. The petitioner has not been permitted phone or in-person or any type of visitation with his family, including his mother, for over 3 years. In addition, the respondents, the sheriff's department, sheriff's office has placed unreasonable restrictions and interfered with the ability of his attorneys to interact with him. And as y'all know, attorneys need to talk to their clients. I mean, if you keep a lawyer away from their client, how would they be able to prepare for trial? This is not any trial. This is a death penalty trial where the state is actually saying we want to take Melly's life. I mean, just to put it blunt, that's what they're trying to do. So you can't keep him away from his attorneys. Let's keep going. This has included forcing his attorneys to wait for hours to see him, not letting them see him at all, and forcing them to meet with him in conditions that interfere with and impede the privacy and privileged nature of his communications with his lawyers. Give us an example. I want to see what do you mean? On or around late April 11, 2022, inmate Jamal Myers filed a grievance report in retaliation of Melly's refusal to purchase him food from commissary. So somebody filed a grievance against Melly, another inmate. Inmate Myers filed a grievance report against not only Melly, but another inmate. Inmate Myers alleged in part that Melly was planning an escape by having his attorney bring in 2 handcuff keys to aid in the escape. Hold up. Melly employs multiple criminal and civil attorneys. Okay, so let's stop right there real quick. So they're saying that his lawyer is supposed to bring in handcuff keys. Who's saying this? Another inmate. There's been no proof right now, and apparently they haven't even called his attorney by name. So that's why they highlighted that he has criminal lawyers and civil lawyers. What lawyer are y'all talking about? How did y'all target one lawyer? Because later on, we're going to see through this lawsuit, they targeted one lawyer specifically. All right, let's keep going. Oh yeah, thank you, Tiff, Tate. Yeah, for the people that's new, y'all don't mind subscribing. Let's go. Not handcuff keys though. What's she gonna get? Let's go. Number 12. In response, correction personnel conducted a shakedown of Melly's cell in the other inmate cell. In accordance with certain supplemental investigation report, the shakedown of Melly's cell unearthed commissary and excessive jail issue clothes, which were confiscated and disposed of per operational orders of the jail. Okay, so it looks like they found some excessive jail issue clothes. What is this about clothes? Because I remember in a YSL trial, they were saying that they got too many clothes in the back. We need, it's too many clothes. We need the space. So I guess in jail, they just want you to wear the same jumpsuit every single day. But they didn't find any handcuff keys, right? Because that's what we're alleging. The other inmate, apparently that's what he said. However, the other inmate of the dorm was found in possession of shanks, prescription drugs, and other contraband. The inmate was subsequently charged for his possession of contraband. Melly was found to have committed no wrongdoing, and the investigation closed as to Melly on April 11, 2022. So the inmate that told Myers apparently said that handcuff keys was going to Melly and handcuff keys was going to another inmate. And when they searched Melly, they searched the other inmate, presumably somebody Melly knows. They didn't find nothing on Melly, but they did find shanks, prescription drugs, and other contraband. Okay, so what this got to do with Melly and his attorneys? Number 14, despite doing no wrong, Melly was moved from his current dorm into solitary confinement, and all phone communication with the outside world ceased. Man. You always have extra clothes, right? Yeah, I mean, that makes sense, right? How you gonna wear the same stuff over and over? Oh, thank you for popping in. First love, let's get it. All right, let's keep going. Number 15, shortly thereafter, two of Melly's defense counsel, two of Melly's lawyers attempted to visit him and were not allowed entry into the jail facility. They stopped him at the door. They said, you can't come in here. The facility refused to provide any reason as to why Melly could meet with his lawyers. The following day, Attorney Stewart made an oral motion regarding the jail interference with plaintiff's right to counsel, Melly's right to counsel. And then the Honorable Judge Andrew summoned the sheriff's department, the sheriff's office, and then another attorney that works for the sheriff's office, Christian, to court. They said, what you doing? What's going on? Why he can't see his lawyers? Then attorney, I don't want to say Tobias, I'll just say attorney T, defended the actions of the facility, stating there was an open investigation against Melly, and further that he was a threat to the security of the jail because he was alleged by attorney T to have been found with a shank in his dorm. This is Melly's attorney here. Adelson inquired if any of Melly's defense team were at the time or ever under investigation, and attorney T responded no. So this is going back to, we recently found out that Melly's lawyer is under investigation, and now we're learning that they said she's sneaking in handcuff keys, which they haven't provided any evidence so far, because we're still this is Melly's lawsuit right now, what we're reading. After we're done with Melly, we're going to read what the sheriff's department said, and they stuff is crazy. But yeah, then Judge Andrew instructed attorney T that the jail could not restrict Melly's contact with his attorneys, and attorney T would have to come up with effectuate plaintiff's visits with his attorneys. So basically, you have to make room. I understand you're saying Melly might have a shank, even though y'all found a shank in somebody else's dorm, not Melly. So, but you still got to let him have access to his attorney. I mean, do y'all think he's gonna stab his attorneys or what? As a result, Melly's visitation took place in a visitation booth located downstairs in the bond room. The visitation booth, the bond room, did not accommodate Melly and his defense team in one sitting. Moreover, it was impossible to review any documentation with Melly due to the plexiglass divider. Oh man, because sometimes we go to the jails, and I practice in multiple counties, and some jails you can hand stuff to your client, they can sign it, hand it back. And then sometimes there's glass, you got to give it to a deputy. Then the deputy got to walk around and give it to your client. It's crazy. It's a lot. And then when you're dealing with confidential stuff, you don't want to give a deputy a paper where she got to disappear out your sight. They can read it. They can take a picture of it. They can copy it and then go all the way around and give it to your client. So a lot of times, if it's something confidential, you want your client sitting right next to you, especially when it's a death penalty case, because you don't want the other side to be what I call cheating, trying to see how your game plan is going to be. All right, let's keep going. Not only was the visitation room not large enough to accommodate Melly's attorney, attorneys, but anyone also standing outside of the room could hear everything. They can hear everything that is said in the room, and that is clearly violating Melly's right to private and privileged communications. Right. So if someone is listening outside the room, that's really dangerous because attorney-client privilege does not extend to third parties. So anybody that listens, that hears, can be subpoenaed to court, and they can tell everything that was said. So you got to be real careful when you're dealing with third parties. That's why attorneys would tell you when you go see an attorney, don't bring nobody with you. Because if they're sitting there listening or they roll with you and they listen to a conversation, they may be subpoenaed. So you want to make sure that third parties stay out of your business. Just tell them when you get in the car. Just tell them when you get in the car. Either that or they better have enough sense not to officially hear anything. All right, let's keep going. On September 7, 2022, attorney Raven Liberty filed a motion to remove visitation, communication, or interaction restrictions. So this is the first we're hearing of attorney Raven Liberty. I did reach out to her office. Her office reached back out to me, and they said while the trial is going on or while it's still pending, they don't want to really comment at this time. Possibly, we can get them at a later date. She can come over here and talk to us. But she filed a motion. She said, hey, Judge, y'all need to remove this visitation, communication, or interaction restrictions. Prior to the hearing on the motion, attorney Raven Liberty contacted attorney T in an effort, and that's the prosecutor that he works for the sheriff's office. She contacted the other side in an effort to reach a resolution without a hearing. Instead, Raven Liberty was met with unhinged screaming from the BSO attorney, questioning her about, what do you talk about? Why do you spend so much time with him? Somebody said on our last live, they better not be trying to go together. They better not pop up no marriage or nothing like that. That's crazy. The lawyer for the jail asking her, what do you talk about? Like she's supposed to tell you her secret communication with her client, which she can't by law tell you what they talk about. And why do you spend so much time with him? Because y'all are trying to take his life. We got to prepare for trial. It's trial strategy. So many documents to go over. So then attorney T ended the conversation in telling attorney Raven Liberty that if she went forward with the hearing, he would embarrass her. He said, file that motion if you want to. You come to court, I'm going to embarrass you, attorney Raven Liberty. Number 25, it is important to note that Melly's defense team was not in possession of the incident report, so the defense team in the court all relied upon attorneys T proffers, and we know how that goes. We've seen that in the YSL trial. You can't just listen to one side proffer because those proffers can be full of lies. But they relied upon attorney T's proffers to the court that have no been determined to be untruthful. Okay, so this is a typo here. They relied on his proffers to the court that have been determined to be untruthful. So maybe they say he's lying. Despite the believable threat of character assassination, Raven Liberty said, I'm not scared of y'all. She said, I'm not scared. Telling you want to embarrass me. I'm going to court anyway. So she proceeded to hearing on the motion. Attorney T ranted and raved about unverified allegations. Sound like Attorney Love and the behavior of Melly. Despite Attorney T's attempt to not only embarrass Attorney Raven Liberty, he failed. Attorney T was instructed to accommodate visitation between plaintiff and his attorneys that was free of third parties being able to listen. So the court said, hey, Attorney T, you got to accommodate visitation. You got to make it work. I don't care what you're talking about. Attorney Raven Liberty should be able to see her client. So on September 29, 2022, Raven Liberty was contacted by a reporter for an online media outlet and informed that an unknown member of the Broward County Sheriff's Office contacted them and led them to believe she was the attorney that Inmate Myers was speaking about in his unfounded grievance. So now they're officially saying a reporter told attorney Raven Liberty that she is the lawyer. She is the lawyer that is being accused of sneaking in or potentially trying to sneak in handcuff keys so Melly can go home. But that's unverified. I mean, what is the evidence of that? Hey, what's going on? Good to see you. I haven't seen you in a while. Thank you for popping in. She said, you ain't seen me in a while because you ain't been here in a while. All right, let's keep going. So a reporter contacted her. So I guess the sheriff's office must have reached out to the reporter and told the reporter, hey, you got to watch Raven Liberty. She's trying to sneak in handcuff keys. And the reporter turned around and told her. They told Raven Liberty. Let's go to number 28. As a result of the accusations of the Broward Sheriff's Office, stories ran for weeks about the alleged nefarious escape plan between Raven Liberty and the plaintiff. Wow. Ain't that crazy that somebody can make an accusation and next thing you know, the news running stories for weeks and weeks. And then they say the escape plan created by Broward Sheriff's Office was not the worst of it. Y'all thought my thumbnail was dramatic. No, they really saying it was an escape plan. All right, December 1st, 2022, under the charge of Captain H, plaintiff without cause was moved to a unit inside the jail that is meant to accommodate 24 inmates. Plaintiff was the only housed on the vacant unit. See, they got some typos going on here. Plaintiff was the only housed on the vacant unit with no privileges, no television, and no access to a newspaper. When plaintiff was allowed his hour out of the cell, all other inmates had to go back inside their cell. So when Melly came out, everybody else had to go in. So obviously they're trying to single him out, and that could be, a form of mistreatment. He's not talking to his family for 3 years. He has no privileges. He has no television. He has no access even to read a newspaper. And even communication with other inmates, he can't do that because when he go outside, they have to go inside and vice versa. Not only that, he's in a unit by himself that's meant to house 24 other inmates, and he's there by himself. So they really trying to single him out completely. Let's keep going. 32, specifically December 2022, Lieutenant Gene Baptiste, along with Sergeant Anthony Kidd, threatened Melly if he told his attorneys about his treatment, they would hide him away from the world. And I will tell y'all this, it has been rumored, it has been cited, you can talk to former inmates, and they say this all the time, the jails will try to hide you from visitation. If there's an incident and you get in a scuffle with a guard and you bruised and battered, they'll put you on no visitation status. That's not a secret. So I believe every word when they say they would hide him away from the world. And they already hide him in the jail because he's in a single unit by himself with no visitation and no access to the outside world via phone calls and, things of that nature. All right, let's see. 33. Plaintiff has not had any phone privileges since May 8th, 2022. The plaintiff, Melly, has not had private visitations with his defense team since March of 2022. As recently, without reason, Melly was moved to the Paul Ryan Detention Center and housed on a floor with no one else. His door had been removed from the cell. Come on now. Y'all are crazy. Preventing any privacy. And he had a member of the emergency, another type of response team, shadowing him, another typo, 24 hours a day. They were instructed not to speak to him. Plaintiff went without any human contact for several months until, again, Broward Sheriff's Office moved him. Yeah, I understand. Sometimes you can type a word and it's a real word, so it doesn't be flagged or underlined red at the typo. But some words, I don't know if it's like a real word, so I'm not sure why it wouldn't be read. And this is the document filed in federal court. And some judges are strict. They don't be playing that. Hey, you got to proofread. But Florida statute 901.24 states that a person arrested shall be allowed to consult with any attorney entitled to practice in this state, alone and in private at the place of custody as often. It don't say when you feel like it, Sheriff's Department. It say as often and for such periods of time as is reasonable. And sometimes it'd be situations, me as a practicing attorney, I might have to go see my client. I might be in court all day and it's starting to be late in the evening. It might start getting night. Okay, I'm already in that county. I'm going to the jail when I leave. So sometimes it may be at night. Make room. clear some space. Oh, okay. See, Bama Girl said Woody testified that he was hid in the mental ward. See, so yeah, it happens. They will hide you. That's why I try to get my clients out immediately, get them a bond right away so they don't have to be dealing with these type of games. But, in certain situations like a capital murder case, the judge can hold you without bond. Let's keep going. The ongoing denial of Melly's access to his attorneys is not only preventing Melly's attorneys from properly preparing for Melly's defense, but is in violation of not only his Sixth Amendment right, but Florida law as well. In order to punish and isolate Melly, the Sheriff's Department have isolated him and not permitted a single phone call, not one, or visit from family in over 3 years. This isolation has inflicted enormous emotional impact on him and is designed to deteriorate his mental health and his ability to prepare for a trial that is now scheduled in September of 2025. Golly, that just seemed like a long time. These restrictions are not for security reasons and bear no rational relationship to any legitimate security interest. The sheriff's office monitor the custody of thousands of inmates and have never imposed such restrictions. This is the first time. No non-Black inmates currently have any such punitive restrictions. Wow, this is a lot. And these are kind of some of the grounds, the legal grounds. And I'm gonna kind of skim through. They basically saying that Melly, his rights have been illegally and improperly violated, and they are constitutional guaranteed right to counsel and his ability to prepare for trial. So they're impeding his rights. These actions have been done with no due process. Okay, so yeah, so they're just kind of repeating the same stuff. Ground two, the respondent has been illegally detained under conditions that are cruel and unusual and not only bear no rational relationship to any legitimate state interest, but violate the petitioner's right to due process and equal protection. Okay, because kind of the same stuff. Exhaustion of remedies. So a lot of times before you can file a lawsuit in federal court, you have to go through the state court. So what they're saying is we followed their process. We exhausted all other remedies. Let me see what they say. It sounds like they have already started hiding him from the world. He's been shuffled around and no family contact. This is insane. Yes, I'd love to speak to his mother so we can talk to her to see what's really going on. Because I can't imagine that they have her communications cut off from her son for 3 years. All right, let's keep going. So exhaustion of remedies on September 7, 2022, and other dates. Petitioner, which is Melly, has continuously sought relief in state court, which relief has been useless. They said state courts ain't helping us. That's why we have to come to federal court. Bringing these constitutional deprivations to the attention of the state court and the state authorities has not provided any relief. So now they're telling the federal courts, you have jurisdiction to hear this case. We tried everything in the state court, and this state court is ignoring us. So we have no choice but to come to federal court. Prison walls do not form a barrier separating prison inmates from the protections of the Constitution. Hence, for example, prisoners retain the constitutional right to petition the government for redress of grievances. So just because you're in jail, you don't lose your rights. That's what they said. You don't lose your rights. They're protected by the Equal Protection Clause, 14th Amendment. They enjoy the protection of due process. Okay. The Court of Appeals, affirmed. U.S. Supreme Court holding conditions and restrictions on jail inmates could be justified only if it furthers an important or substantial governmental interest unrelated to the suppression of expression, and the limitation is no greater than necessary or essential to protect that interest. And the argument is they can protect the jail facilities without having to do all this extra stuff like keep him away from his attorneys. Y'all can find him away. If y'all want him, y'all nervous he may have a shank before he have an attorney visit, do a thorough pat down. After he visit his client, do another thorough pat down. And that way y'all can make sure he doesn't have anything on him, no handcuff keys being brought in. There's ways you can regulate his treatment without being overbearing, without doing the most. And they basically saying they unnecessarily are just broad, just too broad. And that prison officials could effectively cope with the security problems raised by inmate to inmate correspondence through less restrictive means, such as the scanning of mail, potentially troublesome inmates. The district courts have also held that the correspondence regulation had been applied in an arbitrary and well, I don't even know how to say it. What is it? Let's try it. Capricious manner. Prison walls do not form a barrier separating prison inmates from the protection of the Constitution. Hence, for example, prisoners retain the constitutional right to petition the government for the redress of grievances. So yeah, so we kind of get the law. This is the law. And they basically requested for relief. Melly is respectfully requesting that this court issue a writ of habeas corpus, directing the sheriff's office to show cause why he should not be released from unlawful detention and grant such other relief as the court deems just and proper because of the abusive and outrageous violations of his rights guaranteed by the United States Constitution, coupled with the efforts by the state to delay his trial after years of custody. It is requested that the Honorable Court order the petitioner Melly's immediate release from custody. So yeah. So this is insanity. Let me see if I can pull up. Oh. Yeah. So yeah. I mean, this is Melly. So now we're going to hear from the sheriff's office side. Yeah. And the sheriff's office, I'm trying to get that one pulled up. Now they use even bigger words than capricious. So whoever wrote the sheriff's response got an English major. So we gonna work through it though. Goodness, English was not my major in undergrad. Okay, so this is, let me see if y'all can see this. Can y'all make it bigger? So this is the sheriff's office response in opposition to Melly's petition for a writ of habeas corpus. The drink. Oh, this is a lot of reading. All right. So comes now the sheriff, Gregory Tony, in his official capacity as the sheriff of Broward County, Florida, hereinafter BSO, by and through his counsel. All right. And they're basically filing a response in opposition to the petition for the writ of habeas corpus and moves for the petition to be denied and or dismissed because the petitioner has failed to exhaust his state court remedies prior to filing this petition for writ of habeas corpus. We just talked about that. You got to exhaust all your remedies in state court first because they have a younger case. And the younger case applies. And 11th Amendment concerns and Ruker because BSO restrictions on petitioner privileges were implemented for legitimate security and safety concerns. Okay, so they cite a lot of cases. So they got Ruker, they got Younger, they got the 11th Amendment. So basically, they're saying we can restrict him as long as it's for legitimate security and safety concerns. Okay, we got that. We want to know the good stuff. What was Melly doing inside that jail? We know about all that. What was he doing inside the jail? So we got the petitioner, Jamel Demons, YNW Melly. He stands accused of capital homicide for shooting two of his friends and fellow, we got the typo right here, rappers, Anthony Williams and Christopher Thomas Jr. And I want to make sure we don't skip over any important footnotes. Petitioner is a professional musician and rapper with several of his songs, including a song named Murder on My Mind that we played earlier, a song that details petitioner shooting and killing a friend, making the Billboard Top 200 charts prior to his pretrial detention. So you see they had to throw that in there to tell the judge, like, hey, judge, he made a song about the killings, even though it's been alleged that that song came out way before the actual shooting took place. Okay, here we go. Here go my English. Capricious manner means to have an unpredictable, sudden, and unaccountable change in attitude or behavior. Thank you. Let's do a rapper's role. What can we do as a community to make sure that justice system does right? But we have to stay on it. And that's why I reached out to Melly's attorney. And I'm going to reach out to his family too to see if they want to come on. Because I think the YouTube and social media community played a big part in the YSL case. You had the lawyers pushing from the inside, we pushing from the outside to make sure they get a fair trial. So I think we have to just stay on it, especially as it gets closer to the time that the jury is selected. Oh, what's going on? She said, hello, I'm late to the party. He getting out or not? What you talking? What you doing all this reading for? Is he getting out or not? Oh my God. She said, Caleb Bumps and SB. Y'all funny. Oh man, y'all are funny. All right, let's keep going. Okay. Let me read this last sentence right here again. So he's charged with capital homicide for shooting two of his friends, Anthony Williams and Christopher Thomas Jr., early in the morning of October 26, 2018, while driving in his car with his accomplice, Cortland Henry. So he has a co-defendant for the people that may not know. So Melly is not the only one that's going to trial. We got Cortland Henry. And they attached the probable cause affidavit. Melly's criminal case was docketed, okay, and it's still pending in Broward County Circuit Court. Okay, so we know that. Okay, Melly was ordered by the trial court presiding over these charges to be held without bond. The state of Florida is seeking the death penalty against Melly for his crimes. His trial is currently scheduled for September 10, 2025. Melly's other pending criminal case, a witness tampering case, in which he is alleged to have tampered with witnesses for his pending homicide case while in BSO's custody, amongst other allegations, is also still pending and is docketed as that long number. Wow. So they're saying that while he was in jail, he tampered with a witness, and that witness was a person that was supposed to testify at his first trial. And they are alleging that he tampered with that witness. And not only are they saying he tampered with that witness, they're saying that his lawyer, the same lady, Raven Liberty, the handcuff key, she also tampered with that witness. So because she's under investigation for that right now. So, I mean, that's interesting. Miss Audra M. say Cuff Boys called Melly a serial killer. Well, the thing is, he hasn't been convicted of a crime. So, you know, without that conviction, I give pause to labeling someone a serial killer, um, you know, before they're even convicted. But you know, everybody got their own opinion. You know, you got different content creators, and everybody got their own take. She said, "Yep, he was against Melly. A lot of Caucasians were being real racist." Oh wow! See, I haven't seen a lot of that. Let's keep going. Okay. Since his arrest on February 13, 2019, Melly has been held in pretrial confinement in BSO's custody. BSO is the sheriff's office. When Melly first arrived to the sheriff's office, he was housed in a housing unit and was afforded his phone and video visitation privileges, as is any other inmate. He was also permitted phone privileges with all his counsel. Okay, that sounds so. What happened? Number 6, in every housing pod in BSO jail system, there is a day room. Inmates are allowed to leave their cells to go into that day room during the day. Okay. In that day room, there's a television and communal seating. So it's a public area for everybody. In the day room, inmates have access to the kiosk, a computer terminal in which an inmate can log in and submit commissary requests, medical requests, grievances, and read the inmate handbook, amongst other things. Not the inmate handbook. Somebody said they not passing out Bibles in jail no more. They passing out inmate handbooks. Wow. Well, this is so him and his lawyer was committing crimes while he was locked up. This is being alleged by the sheriff's office, but we're going to get to that. They're going to go into more detail in a few more numbers down. But I would tell you this: she's under investigation, and that's why right now they're trying to have her kicked off of Melly's case. But you know, they could say anything, but the question is, where's the evidence? Where's the evidence that she tampered with a witness? Where's the evidence with the handcuff keys? That's what I want to know. And so far, I haven't seen any evidence in Melly's petition or in this response so far. Let me see. Just because we think a person is guilty does not mean they do not have rights. I agree with that statement. Make hope an option. I really agree. Thank you for writing that, because when you start cutting corners because I think that person is guilty, and you cut corners, next thing you know, innocent people start going to prison because we start cutting corners. Okay, we don't have to really we don't have to have a full trial. We know he did it. He looked like he did it, or he was sitting where they say the shots came from. We've seen countless times how many innocent people been to prison and they've been exonerated. So, I mean, I do agree that everybody has a right to a fair trial, no matter what you're accused of. Does Cuff Boys know what the meaning of what a serial killer is? Let's see what it is by definition. Let's see. A person who commits a series of murders, often with no apparent motive and typically following a characteristic, predictable behavior pattern. Yeah. They don't look like that'll fit in that definition. So Miss Susan Fish, she own it. She is on it. At least he was reading. Oh, you mean okay, allegedly committing crime. I got you. He said, I know Melly did it. Well, unless he was sitting in the car with him, which he probably don't want to say that because then he might be a suspect. It's hard to say that you know for a fact someone did anything. All right, let's keep going. Let's keep going so we can get to the good stuff. Also in the day room is a video visitation system terminal where inmates can make video calls with family, friends, and counsel. Video calls made to counsel are not recorded. Y'all see that, right? Video calls made to counsel are not recorded. You have privileged communication with your clients. You know, I think I was raised kind of under the old school. You know, they say your phone's not recorded, but I'm talking in person to my clients. You know, we can call, oh, this is an attorney line, nothing's recorded, just to be safe. You don't want your client to be harmed at a trial because you're talking on the phone. Let's keep going. He said trying to make the day room sound fancy. Let's keep going, y'all. Yeah, they using all this fancy words, big words. Make it plain. Inmates may also access a telephone by using a personal PIN number to initiate video and phone calls to family and friends. These calls are recorded and may be monitored, and inmates are not permitted to use or share their PIN numbers with other inmates, as this circumvents the security measures for monitoring these calls. So they didn't say no security measures that's being circumvented. It's the monitoring. They want to make sure that the person who's using the phone is the person that is linked to that PIN, so they can use that evidence of whatever they say on the phone against that person. Because what difference does it make if an inmate is using somebody else's PIN for security purposes? Because if you're listening to all the calls of everybody anyway, you can hear a security threat coming in. But you want to make sure that you're listening for really evidence to use against that person, because you know a lot of people talk on the phone. You talk on the phone, you know, they play it at trial, and then the next thing you know, you go to jail. All right, so let's go. Number 7. Additionally, inmates may use a telephone to call their counsel via a non-recorded line. However, as will be discussed in more detail, then the undersigned wish was necessary. Y'all catch that shade? The lawyer said, hey, we got to write this in more detail than we really want to, due to Melly's and unfortunately one of his trial counsel's conduct over a course of 4 years, which threatened the security and safety of jail operations. BSO jail administrators found it necessary to restrict Melly's phone and video privileges and to provide him alternative means to communicate with counsel, family, and friends. You're talking about they want to go into more detail than necessary. Now, y'all want to go into it all. Y'all want to put it all. As of today, Melly is housed in an entire housing pod by himself and still otherwise has all the amenities afforded to other inmates other than phone and video privileges. I mean, who want to sit in a big room? I don't care how big your house is. You sitting in there with no phone and no video privileges, you might as well be in a small room. Number 10, his current living conditions are far from cruel or unusual punishment. And in even petitioner's own words, his current housing arrangements are very desirable. So they're saying that Melly's own words saying that his current housing arrangements are very desirable. And they have C letters mailed by Melly. So they got a letter mailed by Melly. These letters were mailed by Melly while he was in a different facility than his current housing assignment, but the conditions of his housing in an entire housing pod by himself are the same. See, so that's an issue for me, because you're saying that Melly, in his own words, saying that his conditions are very desirable, but then when you come down here, you saying that it was a different facility other than his current housing assignment, but the conditions of his housing in an entire housing pod by himself are the same. So it really, he might have liked where he was at first. That don't mean he liked where he's at now. Y'all clearly are saying it's a different facility. So they're trying to, match it all together. Just because he likes one housing pod, you can't say, oh, it's the same size. So if he like it on the west wing, he got to like it on the east wing. It don't work that way. Number 11, petitioner Melly describes being housed in a housing pod by himself as, and I quote, shit, this big like a mini mansion, big. And that it was way better than his previous housing situation in which he was in a housing pod with other inmates. Melly also states that he has better food, and I got a whole unit to myself with a basketball court, TV all day. Oh, wow. They said, wait, shit, this big like a mini mansion, big. Right, they act like he's staying in a hotel. Mr. Bruce said, not amenities. Hold up. They make it sound like he has a cost TV and video game, right? Hey, get him a good Xbox, PlayStation 5, and he'd be all right. That's crazy. Oh man. Okay. Okay, where we at? I got a whole TV by myself. And now they're saying Melly now seems to be taking the position in this action that his housing arrangements are less than desirable. The same sentiment is shared with other letters Melly sent to his family and someone named Slime. Hold up now. Hold up. Hold up now. Who is Slime? Who is Slime? He wasn't writing Young Thug, was he? He wasn't writing Young Thug, was he? Y'all hear what it say? It's enigmatic that the petitioner now seems to be taking the position in this action that his housing arrangements are less than desirable. He shared the same sentiment to his family and someone named Slime. King Slime in the building. Well, now Slime. What's going on in this Brooklyn, NYC? Don't give me the line. I don't know who Slime is. He say, and this is the lawyer for the sheriff's office that's writing. It's also puzzling that Melly comes now before this court and is contesting his phone and video visitation restrictions when Melly's trial counsel indicated in a hearing on these issues before the state trial court that he was not contesting these phone restriction conditions and admitted that these restrictions were warranted for petitioners repeatedly violating jail rules. Now, I mean, that's kind of crazy. I mean, because who wouldn't contest jail conditions when they couldn't use the phone for 3 years, the phone restrictions? I mean, that don't sound right. As far as petitioner's access to his numerous attorneys, he is still permitted to confer with them and his investigators in person and as much as they wish. The records reflect that petitioner has taken full advantage of this opportunity and has met with counsel and his investigators in person over 200 times while in the custody of the sheriff's office. They said they got the visitor log that they attached as exhibit number 6. 200 times may seem like a lot, but when you in jail for 6 years and you have criminal and civil attorneys, that can add up real quick because it may not be the same lawyer every single time. And then not only that, he has state lawyers and he has federal lawyers and he has appeals lawyers. So he has lawyers everywhere. So 200 times is not a lot, especially over a period of 6 years. Likewise, although Melly is no longer permitted phone calls or video visitation with friends and family, he is allowed to send written mail to his family and friends. So they want you to write it down so they can read it. As will be abundantly clear from this response, BSO regulations and minor restrictions on petitioner's privileges are objectively reasonable and for legitimate penological reasons. Okay. And in response to very serious security concerns arising from petitioner's conduct, which is examined in more detail below. However, prior to detailing those circumstances and addressing the constitutionality of the current restrictions on Melly's jail privileges, it's worth pointing out that the petition should be denied for numerous other procedural and legal reasons not directed to the merits of the petition. So they're saying, Judge, before we even get to the good stuff, before we get to the numerous allegations that happened in the jail, you should already throw this case out because of procedural and legal reasons. And some of those we already talked about. The court not even reached the merits of the petition and denying it. First, the petition should be dismissed or denied for the simple fact that he has not fully exhausted his state court remedies prior to filing this habeas corpus petition filed under 28 U.S.C. 2241. It is mandatory for a pretrial detainee to exhaust his state court remedies, and petition has failed to do so. To do this concerning the allegations in his petition for a writ of habeas corpus. So they say he didn't do it. We do know that Melly's petition, Melly's lawyer said that they did, and this response is saying that they did not. And they also have the younger case that's cited. Third, to the extent petitioner is challenging the state trial court's order that denied his motion for release on a monetary bond, and the denied, okay, another typo, and the denied his motion to removal of BSO jail's restrictions, see Exhibit 3, the petition is barred by Ruker in the 11th Amendment. Fourth, petitioner's ground for relief fall outside the core of habeas corpus and are therefore not cognizable in a habeas corpus petition, and the relief requested is also not cognizable. Oh. Okay, finally, the petition should be dismissed because it was untimely filed. They said you filed it late, Melly, you gotta go. You filed it late. You filed it late, you gotta go. You should have filed it earlier. You've been in prison for 6 years. Why are you filing it now? Why are you filing it now? It's untimely. Okay, number 22, I think we're getting to the good stuff. As to the merits of the petitioner's claims, even though the court need not reach the merits of his claims due to, the legal and procedural issues, it is evident from the circumstances that BSO's actions in revoking petitioners, aka Melly's phone and video visitation access, are related to legitimate penological, I hope that's right, penological purposes and for the safety and security of the facility. And quite frankly, it would be difficult to imagine a better factual example, oh wow, of a facility being justified in restricting video and phone privileges of a pretrial detainee. So they're saying this is the perfect example. It'll be difficult to find a better example than the example we have with Melly and why we restricted his access to his attorneys, his access to his phone, put him in a cell by himself. Why did y'all do that? Let's find out. Number 23, when Melly first arrived in the jail in February of 2019, he was afforded all the privileges all other inmates are given, including phone and video visitation. 24, however, within the first 30 days of his incarceration, it was discovered that Melly was violating jail facility rules and regulations, which began a continuous and escalating pattern of behavior and conduct, putting the safety and security of the BSO detention facilities at great risk of harm, resulting in petitioner being charged with additional criminal offenses, including tampering with a witness in a capital proceeding, conspiracy to commit tampering, solicitation to commit tampering, and planned direct criminal gang activity, not the RICO, for offenses occurring between the dates of April 10th, 2023 and July 22nd, 2023, all while he was in custody of BSO using both his jail phone and video visitation privileges in furtherance of these crimes. Okay, that's a lot. That is a lot. I mean, is this all one sentence? Or y'all, wait a minute. Yeah, this is all one sentence. Oh, wow. And the strange part to me is y'all started off within the first 30 days. He went to jail in 2019. And then we're talking about stuff that happened between April 10, 2023 and July 2023. So how did we get all the way from 2019 to 2023 in one sentence? Yeah. Yeah, they cramming this all up, y'all. They cramming it. Oh, she said she had to go. Give him a shank to write letters. This is insanity, y'all. Let's keep going. Number 25. After reviewing the circumstances, it would seem quite bold, to put it mildly, and vexatious. Here we go with these words, vexatious. That petitioner comes now before this court and asks this court to be released from pretrial detention for his pending capital homicide and witness tampering charges, for which he faces the death penalty and in which he was ordered to be held without bond by the trial court, all because of the restrictions of his privileges due to his hand in one of his trial counsel's conduct that, or due to his in one of his trial counsel's conduct that created numerous security and safety issues. Now, they be writing some big sentences at the Broward County Sheriff's Office. I mean, I need y'all to break it up, because a lot of times judges ain't going to sit here and read all this when it's likely they're going to be skimming through. They're going to skim through. Timeline of security and safety incidents. Okay, here we go. The entire timeline of the security and safety incidents created by petitioner's conduct are too numerous. It's too many to fully cover, but it's worth pointing out the most salient incidents. Oh, wow, we're going to get some good stuff. Major Kevin, who was in command of the BSO's Department of Detention, Bureau of Investigation and Projects. Golly. Okay, that's his title. What they call DA Love, Deputy Assistant District Attorney, all type of titles. All right, so Major Kevin, he compiled a memorandum that documents the timeline of events involving Melly over the past few years that led to his privileges being restricted from his own knowledge and from reviewing internal BSO documents, communications, Melly's contact logs, visitor logs, disciplinary records, incident reports, video, and recorded phone calls. Okay, so they got an affidavit to show all that. The first concerns with Melly's behavior began on March 13, 2019. Okay, so now we're back within the first 30 days, because we know he went February of 2019. So now we're back to March 2019 when petitioner Melly received an internal disciplinary report. For shorthand, they're going to call it DR, written for violations of conduct which disrupts unauthorized phone use and unauthorized phone act. Okay. So I got some exhibits there. It was discovered that on February 17th, Melly, who was housed in Unit 7A2, initiated communication with his co-defendant, Henry Cortland, okay, via a three-way call. Henry Cortland is a co-defendant. Okay. So we got another typo here. Henry Cortland is a co-defendant in Melly's pending capital homicide case. Inmates are not permitted to communicate with other incarcerated co-defendants within the jail facilities for safety and security reasons. A review of the jail security camera system verified that both inmates were present in their housing units communicating on the phone. Melly was found guilty and received 30 days disciplinary confinement with loss of privileges by the DR hearing committee. So he was found guilty. I guess they got some type of little mock court in the jail. They have a committee and the people vote guilty or not guilty. But come on now, it's a jail. Everybody in there guilty. They're gonna find you guilty. That's why we don't use military or a group of professional jurors. That's why when the Constitution was created, they wanted a jury of your peers, your everyday citizens, not somebody that's gonna, like a military court tribunal, and they're gonna all just vote guilty every time. So it's supposed to be a jury of your peers, and sometimes you don't get that. On March 29, 2019, because of policy violations regarding the uses of the phone, Melly had his phone privileges restricted to attorney calls only from March 2019 to April 2022. Between March 3rd and March 15th, 2019, there were a total of 24 phone calls made from an account associated with Melly. However, the inmate making the calls was not Melly, but another person portraying himself as Melly. Okay, so if somebody's acting like they're Melly and they're using their own phone, how can you attribute that to Melly? Unless y'all have some evidence showing that Melly told them, hey, pretend like you're me and call this person. Let's keep going. This inmate got a civilian to put money onto another female's phone. Okay. This inmate got a civilian to put money onto another female's phone. Melly participated in the violation of policy as he initiated the call by using his unique PIN and having his voice verified before the call could be placed. So what they're saying is Melly started the call with his PIN and then gave the phone to somebody else. I mean, because if he started the call, why not just do it himself? Why have somebody act like they're you? But in any event, let's keep moving. On June 24th, 2019, Melly was counseled for being disrespectful towards staff, stating to the deputy that she needs to go home with her stank. Hold up. With her what? Y'all know I'm not going to read that on YouTube. I'm not going to do it. I'm not going to. Didn't they say somebody in the YSL trial may have, had an issue or remember when Woody, started waving his hand like he smelled something? I don't know if it's true. I don't know. This is allegedly. Wait a minute. And you know what? Melly say, we know it stink because you be at work all day. Say it ain't so. And y'all, to be clear, this is what the sheriff's office is saying that Melly said. We don't know if he said it. We don't have any evidence of it. They say they got an exhibit here, but I'm sure just a report of somebody saying that he said it. But this is insanity. Why you? Come on now. Come on. He said, we know his thing. Hold on, let's go back. They have to counsel him. I'm like, Mr. Root, not counsel him to have manners. Hold on. This, hey, Melly, you can't do that. You can't tell our deputy that she needs to go home with her stank AP. We know it's stank because you be at work all day. You can't do that. Oh my God. What is going on? Okay, number 32. On July 19th, petitioner received a DR, and I guess that's what we say DR was. I think a disciplinary report, something like that, for threatening another and refusing to obey an order while housed in Unit 6D. Melly refused a verbal order to return to his cell after being disrespectful to staff. Petitioner stated, F that shit. I ain't doing that shit. The deputy attempted to provide a custodial touch to escort him to his cell. Yeah, okay, yeah, that custodial touch. Y'all probably pushed him. Y'all know how y'all be grabbing their shoulder and push him. But anyway, a custodial touch to escort him to his cell. And petitioner then pushed his hand away and stated, don't touch me, mother. You don't know who I am. Melly continued, I'll have my people take care of you in the streets. No. Now, why y'all ain't charging with that? Right. Y'all ain't, nobody can know nothing. Yeah, I agree with Pretty Eyes T. He definitely should have got a bond, especially after the mistrial, because that alone tells that there's some type of reasonable doubt going on when you have a trial and you can't get all of those to agree. So he could be presumed innocent just based on that first trial alone, because you got to have 12. And even the 9 that voted guilty was not even guilty for capital murder. That was guilty for manslaughter. And that's a lesser offense that doesn't involve the death penalty. That's what he said about Hilton. Back up. I remember he said back up, but I don't know if it was because he smelled it. He was just like, back up, back. We like, what the hell wrong with Woody? They said Melly just right. They could put an ankle. I agree. They could put an ankle monitor on him. Judges that have reservations, they do it all the time. If they think your client's dangerous to the community or they may not show back up to court. They may try to run the race like a rapper named TK. He said, I'm gonna run the race. Y'all gotta come get me. They can put a monitor on you, ankle monitor on you, but of course, you have people that cut those off too. I mean, quiet as it's kept. Would he put his hand over his nose and like, oh wow, let's keep going. Yeah, Melly is a character if these things are true and they haven't been verified. Because y'all know, like I know, we seen it in YSL. The police can say anything. What the evidence at? Somebody say, what a body cam at? Who put that in there? Somebody had that in the chat. I thought I saw it. Somebody said, what a camera at? Oh my God, y'all, this is some crazy stuff. And I don't think that's the half of it. We got to keep going. All right, let's keep going. Okay, number 13. During the disciplinary hearing, the DR, for July 19, 2019 incident, Melly stated to the disciplinary committee that he never threatened the deputy or disrespected. Melly said, I ain't do that. He lied. Melly was found guilty, of course. Who's surprised? And he received 20 days disciplinary confinement with LOP. And I think LOP was loss of privileges. I think that's what they used earlier. And 10 days probation. During the hearing, Melly asked if he could serve his lockdown on the 8th floor because I'm a celebrity and I don't want inmates in my face, and requested, what can I do to get there? Melly said he a celebrity. He said he want to be on the 8th floor. He want to be at the top looking down. He want to be in the sky rise. He said, I'm a celebrity. And he don't want him in his face. All right, let's keep going. On September 12, 2019, Melly received a DER written for threatening staff and conduct which disrupts while in Unit 7B2. So I guess he didn't make it to the 8th floor. Maybe he made it to the 7th, 7B2. Petitioner used his towel to clog the toilet until, wait a minute, where'd it go? Okay, until the entire housing pod was flooded with water. The deputy entered the unit to turn off the water when Melly stated, yes, I flooded, now go get your sergeant. I'll beat you all. I have real lawyers to get me out of here. Oh, wow. So they saying he flooded the toilet. What a body camera at? Where is the body camera at? Yeah, you definitely can't forget about due process for sure. He said, y'all flood this bee. And he said, I'll beat y'all. I'm trying to keep it clean for YouTube. But come on. Y'all see what it say. Do I need glasses? That's what it say, don't it? And then, of course, he was found guilty by the kangaroo court. Somebody listed. They threw something together. The jail court found him guilty, and he received 20 days disciplinary confinement with loss of privileges and 10 days probation. I don't even know what the probation consists of. They say Melly admitted to flooding the cell but denied threatening the staff. On September 25th, 2019, he was placed on room restriction for passing and receiving items under another inmate's door. So what's the big deal with that? Pass a note, hey, what you doing? You can't really talk. They send it back. They call it a kite. November 26th, petitioner refused orders to go back to his cell, stating, y'all gonna stop effing with my business, ask about me. I'll flood this bee. Oh my God. Not flood this. Hey, y'all heard what he said? He said, I'm gonna flood this bee out. Keep playing with me. Y'all better ask. Y'all saw what happened last time. I clogged his toilet up. Okay, this is crazy. December 5th, 2019, petitioner was moved to a different cell due to masturbating towards the female style. Golly. Come on. This lawyer for the sheriff's department is messy. He messy. He was like, I really don't want to put, I really don't want to have to say all this. But while I'm at it, I'm going to say everything I know and everything I heard and everything they heard. So he really don't have to. He really didn't want to put it in the. Yeah, you did. Yes, you did. Because who told you to write all this? And if we only on page 7 of 31, I know you lied. I know you lied. Oh my God. Oh my God. Miss Susan, that is crazy, right? Yeah, that's what they said in Fulton County. 38. December 15th, Melly was counseled again. They were counseled for sitting on the unit table and after several orders to get off, stating, F your table. I'm not an inmate. I'm a superstar. Call the sergeant. Not the font change. Y'all see how they changed the font? What they do? Unbolded? What, unbolded it or what? I mean, they didn't italicize it or underline it. All right. In any event, then on December 18th, Melly was counseled for talking to inmates in other units while in the vestibule area, being escorted to the attorney interview, and then again upon his return from the interview. On December 25th, on Christmas, he was counseled again to stop passing notes through the door to the adjacent. Come on now, y'all. Y'all got to remember, these people locked in 23 hours a day. It's Christmas. They passing notes. They passing, it's a jail door. So really the only thing that can fit underneath the door is a piece of paper. It ain't like they can fit a whole shank or objects through the door. If y'all doors that high, y'all need to get some new doors and lower them to the floor. But yeah, they said unbold, right? I mean, that's what it looks like. They just hit unbold. I mean, like what? I mean, I've never seen that to make something stand out. Since the whole thing is bold, you unbold the part you wanted to highlight. Like, okay. Let's go. So January 17th, Melly was placed on a 2-hour room restriction for going to another inmate cell upon return from a visit. He refused orders to move, stating that he didn't give a F. And stating to the deputy that she is a what? A P.A. Ho. Oh, me. No, you didn't tell that woman that, Melly. You did not tell that woman she did what? And this is all allegedly, y'all. We don't have any confirmation of it. But this is some good stuff. For entertainment purposes. I mean, this has no bearing on the trial itself, right? This doesn't go towards his guilt or innocence and the young men that lost their lives, RIP to them. But as far as the behavior in the jail, this is courtroom gold. I would have been like, if I'm sitting at the house reading this, the judge like, wait, say what? You have to sit up, get you a good cup, and do your face. Oh. She said, what I missed. Well, what did you missed a lot? You missed a lot. You missed a lot. Okay, let's keep going. And these are not criminal offenses just because you're calling somebody out their name. I mean, it's not illegal. Okay, February 20th, 2020, Melly was involved in a mortar. How many people was it? Inmate fight inside the day room area of his unit and was given a DR for his role in the fight. The day room, they tripping me out with that. The day room. So they didn't have one fight. So we in 2020, and we got our one fight. October 25th, 2020, petitioner was placed on room restriction for refusing to go back in his cell as he was trying to hide while on the phone. April 5th, 2021, after being allowed out for a video visit, petitioner was observed on the phone. Okay. He refused to return to his cell and get off the phone. The deputy had to go into the unit and he still refused. His next video visitation was canceled as a result. Also on April 15, 2021, Melly was placed on room restriction for being in an unauthorized area on the phone while out for medication rounds. I mean, they just really, man, this is a lot of this stuff is kind of like petty to me. I mean, if the cell door unlocked, then, you know, they out and about. Y'all want to lock down for a specific period of time, you know, lock the doors. On May 4, 2021, during a video monitor spot check by video visitation staff, it was discovered that the petitioner's attorney, Raven Liberty, was allowing non-attorneys to use her login credentials to conduct privileged, non-recorded video visitation with Melly. Wow. So now they are making an allegation that his attorney, not only are they saying she was, you know, allegedly sneaking the handcuff keys, she tampering with witnesses. Now they're saying that she using her login credentials to let other people, you know, talk to Melly. And my issue with this is, if she's using her login credentials and y'all have evidence of this, then you can say, okay, you lose your video privileges, so you have to come to the jail in person. But I don't understand that because something happened on video, you stop her from visiting him in person. Because, I mean, if anything, you stop her from doing what the issue was. And the issue was her sharing her login credentials. If that's even true, you know, we got to put that out there. Somebody said, you mean his boo? We go together. Tell them where we go together. They don't go together. Stop that. Stop it. She said his boo. Don't give me the line, Mr. Bruce. You might be on to something. I don't know. Oh, man. But they do be sitting up in each other's faces a lot. But, you know, they working. They whispering and carrying on. He ain't got nobody else to talk to. I know she kind of, you know, older than him, probably old enough to be his mama. He probably like, hey, 6 years, he gonna work with what he got. That's a joke. That's a joke. He not going with his attorney. We're not gonna put that out there for they be saying now they going together. They Talk That Law said that he has evidence that they going together. Then we gonna be in emotion. Oh my God. Okay. So they're saying that she let somebody use her login credentials. And it could be somebody at her office or one of his girlfriend, and she slid in. But another issue I have with this is, what do y'all mean during a video monitor spot check? First of all, why are you watching? I don't care what you call it, a spot check or whatever you want to call it, confidential communications between him and his attorney. Because had you not even been watching that video or calling it a spot check, you would have never known that his attorney was letting somebody else talk on the computer screen. So that right there, I think, is a violation. And that's why the lawyers do not trust the phone. She can't talk to her client. She got to talk to him on a phone through a glass. Y'all might be recording it because now y'all put in y'all own, this is y'all own response. This is not Melly's lawyer saying that. Y'all are saying this, that y'all did a spot check of an attorney client visit, and that's when y'all noticed that somebody else was using her login credentials. So we're going to talk about her giving out her login credentials. We're going to talk about y'all illegally listening to attorney-client privileged communications. So we're not gonna let that slide, while we here. Dirty work. Yeah. I mean, come on. Some ain't clean in the water. Some ain't clean. Let me see. This is a serious security breach. No lie, it is a serious security breach when you're hacking an attorney's video call. But yeah, this is a serious security breach, and as a result, BSO permanently restricted all video visitation privileges for Miss Liberty. Miss Liberty is one of numerous attorneys hired by a petitioner for his criminal case. The thing is, when they say that, what they're saying is Liberty don't have to come. He has a lot of attorneys, so let one of them come. That's not for us to decide. That's not for the jail staff to decide. And that's why they put that sentence in there. Miss Liberty is one of numerous attorneys. So he don't need to talk to her. Let her talk to one of the other ones. That's not y'all decision to make. He has the right to choose his counsel himself. On August 17th, 2021, petitioner received a DR, disciplinary report for conduct which disrupts and disobeying facility regulations while housed in Unit 6C3. Melly violated the video visitation policy by engaging and encouraging inappropriate behavior during the visit. What'd he do? What'd he say? What's inappropriate behavior? Because it may be inappropriate to you, but not to us. Melly's mother, Jamie King, was taking pictures of the video visit. Okay, so she ain't seen her son. You know how they like to do, take a picture of the video visit so they can post it on social media. All right. During the hearing on the DR, petitioner stated Melly stated this is double jeopardy because I already had my visits taken for 90 days. Melly was found guilty, of course, by the jail play court and received 30 days disciplinary confinement with loss of privileges. So, I mean, I kind of get it. They've been disciplining him for 30 days, 60 days, 30, 20. And he's saying, hold on, this is a lot. This seems like he put that legal term on him. This seems like double jeopardy. Y'all are punishing me twice for the same thing. And in fact, I don't even know why would y'all be punishing him at all if Melly's mother was the one taking pictures in the video visit. If anything, y'all could tell her, like, hey, that's not allowed. If you do that again, we will suspend you from being on the video for, a week or 2 weeks, 30 days. But I don't know why y'all would punish Melly. I mean, so I think he has a right to be upset. On August 18th, BSO, the sheriff's office, they modified Melly's video visitation privileges due to his refusal to adhere to the visitation rules. All video visits would now have to take place at the on-site video visitation center where staff could more closely monitor the video visit. Well, first of all, y'all already closely monitoring the video visits because you're secretly watching his lawyer stream. Come on. Talking about they want to monitor his conversations. All of this seems as if they want to get any dirt on him they can to use it against him at trial. Let's see. Up to this date, there had been 110 different video visitation violations involving the petitioner. They say he violated 110 different times, but as we can see, the examples that they listed was one that his mom took a picture of, and they said his lawyer gave out login credentials that he was talking to someone through the lawyer's account. And this is, if we take it to be true, Melly has repeatedly violated policy. He was suspended on multiple occasions, but continued violating visitation rules once it's reinstated. April 7th, 2022, Due to Melly's constant manipulation of the phone system, an order was given that phones are to be always turned off in Melly's assigned housing unit when he is out of his cell. Only attorney calls with a sergeant on post on viewing him would be allowed. God, that's crazy. So anytime he out of his cell, all of the phones have to be off for everybody. Golly, that's crazy. April 8th, April 11, 2022, a confidential tip. Here we go. Confidential. Y'all got to watch that too. A confidential tip was received regarding inmates Nicholas Lewis and Melly regarding a plan to escape from the jail by having petitioner's attorney bring in 2 handcuff keys to aid in the escape. So we have a confidential, of course, it's a random person that they're not going to identify in their response, saying that someone told them that a lawyer will be bringing in handcuff keys. An incident report was written, okay, describing the tip about the escape attempt and contraband seizure attached, okay. Additionally, the confidential tip alleged Lewis was selling drugs, but the informant did not provide any other details about the drugs or location. Okay, so we have a confidential informant saying something about some handcuff keys that's going to be took to Melly and to Nicholas, and Nicholas was selling drugs. Okay, we got it. A search was conducted in both inmate cells, Melly and Nicholas. 1 metal shank, 2 razor blades, 2 big lighters, and 13 rolling papers were found in inmate Lewis's cell. So Nicholas had all of that in his cell. He had a shank, razor blade, so nothing yet in Melly's cell, because after all, this is who we're talking about. During a strip search of Nicholas Lewis, 16 pills were also discovered on his person, but he did not have a prescription for. It. Okay. As a result of a search of petitioner's Melly cell, Melly was found to be in possession of a pen. Okay. Not a pen. That's what y'all got? A pen? An ink pen? And excessive amounts of what? Of commissary. Wow. So Melly, the big time criminal. Melly has ink pen and excessive commissary. And commissary, y'all know, is like the snacks. It may be noodles, it may be chips, it may be candy, drinks. Okay, big deal. But we haven't found anything on Melly that's illegal. We haven't found any handcuff keys, because that's what the confidential informant said. There's going to be some handcuff keys. Where they at? That's what we're looking for. Melly then received a DR written for possession of unauthorized articles while housed in Unit AC3. So the 8th floor. See, my thing is they're really picking with him. How can you have excessive commissary? Did y'all let him buy it? You have sometimes it'll be states that have laws. You can buy what marijuana, or they can sell marijuana or synthetic marijuana, but it's illegal to possess it. Well, if it's illegal to possess it, it ought to be illegal to sell it. Because soon as somebody go into a smoke shop and buy it and they come out, now all of a sudden it's illegal. So I mean, I think it's the same here. You sell them a lot of commissary, and then you write them up for having said commissary, which is a form of entrapment. If you ask me, you set them up to get in trouble. Petitioner then received a DR written for possession of an authorized article. Okay, I read that. During the hearing, petitioner stated, "I had no idea the pen was there." Melly was found guilty. Here we go again, and received 30 days probation. This is the crazy part right here. Because some of the information received from the informant was verified, and because one of the allegations from the informant was that Melly's attorney will be bringing in the handcuff keys, BSO temporarily suspended in-person attorney visitation for both inmates. Now that's insanity. A confidential informant told y'all somebody had his handcuff keys, But based on that one person's word, y'all didn't find any handcuff keys. You definitely didn't find anything on Melly. You suspended his in-person attorney visitation. And when you have evidence like this, it's really hard for me to, believe the evidence you present at trial, because I'm looking at evidence that you present in your own filing. This is y'all writing this. I didn't write this. This is y'all response to Melly's lawsuit. These are y'all words, and y'all are saying that y'all suspended him from seeing his own attorney just because some random person who could have been mad at Melly told y'all he had handcuff keys that y'all did not find, and the only thing y'all found was snacks and an ink pen. That's insanity. Yeah. Let's keep going. On April 13, 2022, BSO resumed in-person visitation for petitioners' attorneys, Raven Liberty, David Howard, and Stewart. But for security purposes, the visits were conducted in the bond room through a glass barrier, separated room sharing a window and a telephone to minimize the risk of contraband or a handcuff key from being given to the petitioner. Ain't that crazy? I mean, a easy fix to this is you give them a shakedown before they go talk to their lawyers. And a lot of jails do this. Once you have a visit, even if it's not with an attorney, it's with the general public. When you go back there, they're gonna search you again before you come back. But because some person said they have, they may have a handcuff key, who we don't even know that person, according to y'all response. You stopped him from visiting his 3 attorneys, or what? Yeah, Raven, David, and Stewart. And not only that, you put them behind a glass. Not only that, they have to talk to their client through a telephone, hello, so they can listen. Allegedly listening to their conversations. I mean, we can think y'all listening. We already know for a fact y'all are watching video conferences between attorney and client. I mean, y'all said that yourselves a few numbers ago. All right, let's keep going. Number 51, August 25th, 2022, Melly was given another DR for conduct which disrupts and unauthorized use of telephones while housed in Unit 82. Okay. Petitioner Melly was discovered using inmate Brown Arvis's telephone pen to utilize the phone. Okay. I mean, y'all stopping his phone privileges, so he's using somebody else's phone. During the disciplinary hearing, petitioner stated, Melly stated, I did use his pen without his knowledge. So Melly took the blame if what they saying is true. I did use his pen without his knowledge. So he's saving that guy from getting in trouble. Melly took responsibility. He, of course, was found guilty and received 30 days disciplinary confinement with loss of privileges. Right, that's a good question. Somebody said, Miss Susan said, why is he in handcuffs anyway? I mean, will he need handcuff keys to escape? Because normally once you're inside the jail, you're not in cuffs. I mean, you're walking around free. If anything, you're going to need a key to all the jail doors, the cell doors, and stuff like that. You don't need no handcuff key to escape. But yeah, that's a good point you pointed out. Let's keep going. September 7, 2022. Miss Liberty filed a motion in petitioner's criminal case to remove all of Melly's visitation and communication restrictions. So Melly's lawyer filed saying, hey, remove these restrictions. We good. We y'all have no evidence I was going to bring in any key. And September 15th, Melly, despite his phone restrictions, conducted a relay phone call to his girlfriend, Erin Barnett, through another inmate who was using a third inmate's unique pen. That's a whole lot, ain't it? They're saying Melly conducted a relay phone call to his girlfriend through another inmate, and that inmate who was using a third inmate's unique pen. Oh, wow. At the 3-minute, 30-second mark of the call, Barnett says to the relay inmate, Did he see my pictures? I sent her my pictures like 2 days ago. The relay inmate repeats, did you send him your pictures? She says, his lawyer. The relay inmate says, no, he did not get them. Barnett says, no, tell him if she don't got them to him, and that's the typo, if she don't got them to him by next week, I'm going to beat her ass. Oh, wow. So they're saying the girlfriend said if Raven Liberty, allegedly, we don't even know if it's her, she just said his lawyer, that could be anybody. If his lawyer doesn't give him pictures, she gonna beat her. So hey, somebody said his lawyer not gonna give him no naked pictures. She in the race. She in the race. She ain't gonna she's trying to be next. No, I'm just playing. All right. Barnett continued discussing petitioner's female attorney in the call. At the 11-minute, 25-second mark of the call, the relay inmate reiterates, my job is to repeat everything that goes on this phone. And here they go. They're trying to assume Raven Liberty is the only female attorney retained by Melly in his criminal case. It should be noted that attorneys are prohibited from bringing personal items into the jail and passing them to an inmate. And doing so is a criminal violation of Florida law and jail rules. This relay phone call made on Melly's behalf in violation of jail security rules, coupled with the previous incidents, y'all know they like these long run-on sentences, coupled with the previous incidents involving violations of phone and video visitation rules, heightened security concerns regarding inmate petitioner and his attorney, Raven Liberty, that she may not only smuggle in contraband photos of Melly's girlfriend, but also continued concerns she was the one discussed by the CI to smuggle Melly a handcuff key during the visitation. Oh, wow, that's a mouthful. That's a mouthful right there. So they're saying you have a CI saying that his attorney was going to bring in a key that hasn't been verified. Because they didn't call her by name, and now you have a conversation between 3 people. They said Melly talked to one cellmate, the cellmate talked to another. You have a relay inmate, and those people are saying that the girlfriend sitting on the phone. Did she bring my pictures? His lawyer. Did she give him my pictures? His lawyer. And y'all are using that as a basis of stopping his lawyer from visiting him. So right now we have no concrete evidence. I mean, if it was me, if I was the sheriff, I need some concrete evidence before I stop a client from visiting his attorney. If she come in one day and y'all catch her with some pictures red-handed, okay, that's one thing. She come in one day and y'all catch her with a handcuff key, that's one thing. And both of those are criminal offenses, by the way. And then y'all got her. But what y'all saying is, he said, she said, that the other person said that she was supposed to give her some pictures. Right. And then you have a confidential informant that said, hey, go to his cell, shake him down, but they didn't find no handcuff keys. So this is making it really hard for me to trust y'all capital murder evidence when we can't get y'all to tell the truth in a motion. We can't get y'all to tell the truth in y'all response. This is insanity. So on September 16th, Melly was again allowed to use his phone to call his lawyer. Instead of calling his lawyer, Melly utilized another inmate's pen to call his girlfriend Barnett. At the 7-minute, 30-second mark of the call, Melly tells her, hey, I'm supposed to be talking to my lawyer. Whenever they call you, be like, is this Miss Liberty? Is this person? Just be like, yep. And Barnett responds, when who calls? Yeah, see, she didn't catch on quick enough. But Melly responds, when I call, they going to be, is this the lawyer for Jamel? Just say yes. Melly says, when are they? Okay, so this is a typo. Petition, so that should be Barnett says, So the girlfriend says a typo. Barnett says, when are they going to do that? And then Melly says, one of these days, be prepared. Oh my goodness. Well, we got to decipher through this. This is we got to decipher through this. Y'all need to know how to write a response. Goodness. Oh man. Okay, so here we go. On September 21st, 2022, the BSO, the Sheriff's Office, reinstated regular non-barrier in-person visitation for Melly's attorney, the main attorneys, David and Stewart. But they said Raven Liberty, the barrier visits were maintained for her due to the heightened security concerns regarding her specifically. What heightened security concerns? That 3 people removed down the line were talking on the phone about some pictures. They never called her by name, but y'all assumed it was her because she's the only female attorney, and a CI, confidential informant, sent somebody a handcuff key. Y'all got to keep her behind the glass talking on the phone. Yeah, y'all keep her behind the glass because y'all want to listen to their conversations through that jail phone through the glass. And like y'all were listening to her videos when y'all found out that she shared her login information with somebody else. See, we're gonna break it down. We're gonna break it all the way down over here. Yeah, I don't believe none that's spelled right. Yeah, they lie so much they can't even get it right. Okay, September 27, 2022, a hearing in the criminal trial court was held on Melly's motion to remove visitation, communication, or interaction restrictions. Okay, see the transcript. During the hearing, BSO Assistant General Counsel Attorney T attended on behalf of BSO and asked Ms. Liberty if she received or accepted photographs from petitioner's girlfriend, but petitioner's attorney Stewart instructed Ms. Liberty not to answer, and that she did not need to answer that question. So apparently the sheriff's deputy, the sheriff's office attorney, Attorney T, asked Miss Liberty if she received or accepted photographs from petitioner's girlfriend, and one of Melly's other attorneys told her not to answer that, and she did not need to answer that question. And I agree. Y'all already saying that y'all already accused her of receiving photographs when you have no proof of it. Y'all already stopped her visits, and now you want to ask her to help you. Not only that, you already said earlier, a few sentences ago, paragraphs ago, whatever y'all got going on here, all of it's running on. Y'all said that it's a criminal offense. So you want her to, even if she did do it for the sake of argument, you want her to admit to a criminal offense? Nah, she have a right to remain silent. And I don't even think receiving a photograph is the offense, but I'm thinking taking it to the jail is the offense, because you can't help what someone send you. I can send you a text to your phone right now. Yeah, you received it, but you didn't authorize it. The girlfriend could have sent it on her own volition, her own free will. But let's keep going. But yeah, I agree. Don't answer nothing. I'm not answering nothing. I'm the attorney. I'm not even the one under oath. You're not questioning me. I'm not even on the witness stand. So later in the hearing, the question was posed a second time to Miss Liberty. But again, Attorney Stewart, he interrupted, advising her that she did not need to answer. And guess what? Miss Liberty did not answer the question as she should. Come on. Come on here, Liberty. With liberty and what? Justice for all. Let's go. During this hearing, petitioner's effort to get Miss Liberty to smuggle photographs of his girlfriend to the jail as contraband was also discussed. I don't think that's true. During this hearing, Melly's effort to get Miss Liberty to smuggle photographs of his girlfriend to the jail as contraband was also, I don't think that's true, because based on what y'all just said, it wasn't even Melly's effort to get his lawyer to smuggle in photographs. Y'all said it was his girlfriend talking to a third person about her being mad at Miss Liberty for not giving them to Melly. So it seems as if it was the girlfriend that was trying to get Miss Liberty to smuggle the photographs in. That's neither here nor there. But I just want to point out that discrepancy. 59, during the hearing, BSO Assistant General Counsel Attorney T revealed, y'all have to use his whole, I mean, we on number 59. We know who he is. Y'all don't have to. Broward Sheriff's Office Assistant General Counsel Christian revealed that from February 13th until September 22, Petitioner Melly has continuously violated BSO jail phone rules by facilitating three-way calls to speak with his co-defendant, utilizing other inmates' personal identification numbers, PIN to make calls, and conducting relay calls using other inmates to send messages on his behalf. All right, golly, this is a lot. During this time, 3,041 calls were made by Melly or other inmates on Melly's behalf to his girlfriend, Erin Barnett, alone. So they're saying that either Melly or other inmates calling on behalf of Melly called his girlfriend 3,041 times. And I don't even know how long Melly been. I think the judge said Melly was in jail for 2,170 days. So about, if you round off 2,000 days times 2,000, that's 4,000. So even if he was to talk to his girlfriend twice a day, in the morning and at night, that's 4,000. So 3,000 is really not that bad for as long as Melly's been in jail. That's not even twice a day. I mean, somebody can do the math, but that's not even twice. Yeah, and how do they know how many Melly was making on his own and how many other inmates was talking to Barnett? Okay, here we go. Only 22 of those calls were made using Melly's PIN number. And then they got his phone logs. Okay. Furthermore, Attorney T provided information to the trial court that on September 22nd, while on complete phone restriction, phone pins for 4 different inmates were used by Melly to facilitate calls made by him and other inmates, to include those inmates making relay calls for Melly. Additionally, Attorney T, now he Attorney T, he not Deputy District Attorney, Christian, all that. He provided information on September 26, 2022, just one day prior to the hearing, an inmate used another inmate's PIN to make calls for Melly. This included a 3-way call to Melly's mother requesting that she add $100 on his account and another unidentified person's account. Okay, so who's the other unidentified person? Y'all listening to the calls, or is this word of mouth? During the hearing, Melly's counsel conceded there were phone violations and did not contest BSO's phone restrictions any further. At the conclusion of the hearing, Judge Siegel did not restrict BSO from utilizing barrier visits for Miss Liberty. So I guess the judge went along with the sheriff's office. He did not stop it. BSO was instructed to find but they were instructed to find an alternative barrier space other than the bond room to accommodate the entire defense team to meet with Melly, which the sheriff's office said they complied with. BSO was not ordered to reinstate Melly's phone or video visitation privileges. And that's another reason. See, you just said it yourself. BSO was not ordered by the court to reinstate Melly's phone or visitation privileges. And then you say, why are we in federal court? Because they asked the state court. You said it yourself here. And the judge did not order it. He said, the hell with it. And that's why they in federal court. All right, on October 27, 2022, Melly received a DR for conduct which disrupts while housed in Unit 8B2. Exhibit 9 the investigations division discovered that petitioner had passed a note from Unit 2 to Unit 1 instructing inmate Lamar Johnson to make an unauthorized telephone call from petitioner and to share his personal telephone. During the disciplinary hearing, petitioner admitted, they're saying Melly admitted that he slid the note. However, according to Melly, the note did not request for the inmate to make a call. Petitioner Melly was found guilty and received 15 days lockdown, golly, with loss of privileges. Y'all, this is insanity. And I don't think this half of it. On November 15th, a letter was discovered by BSO mailroom that appeared to be suspicious. Here they go. Everything's suspicious to y'all. Melly was listed as the letter sender with the return address of P.O. Box 9356. And the letter was addressed to the law firm of who? Aaron Barnett. Not Aaron. Wait a minute. So his girlfriend just started her own law firm, y'all. So they said that it was the letter was addressed to the girlfriend address somewhere in Texas. The address was confirmed to be a residential address and not an attorney's office. Aaron Barnett is the girlfriend of Melly, who he had previously told to identify herself as an attorney when he was only allowed attorney phone calls. Melly received a DR for this incident. All right. The contents of inmates' legal mail addressed to attorneys are not monitored by jail personnel. I don't believe that. And this letter was an attempt by Melly to circumvent the jail's mail security rules. November 29, 2022, it was discovered that petitioner used inmate Marcos's phone pin to call his girlfriend 40 times since November 19, 2022. Okay. Also, November 29, inmate Dexter Scott made a call for Melly to Melly's mother because Melly phone privileges were restricted. Melly said he wanted posts on Instagram about the incident. November 30th, due to numerous repeated violations of the phone use rules, Melly was not allowed to use the phone under any circumstance. December 1st, Melly was found with inappropriate photos of a female. Y'all see that? They caught Melly with inappropriate photos of a female. How did he get those inappropriate photos? Somebody take a guess. How y'all think Melly got those photos? Y'all think his lawyer snuck him in there? Y'all think attorney Raven Liberty snuck him in there? All right, nobody gonna put it in the chat. Nobody ain't gonna guess. Fine, I keep going. What's going on, Stephanie? I was just thinking about you the other day. I had came on live a couple of days ago, and I was wondering, I said, where's Stephanie at? Happy New Year. Yeah, I hope all is well. Good to see you, his lawyer. Okay, so we got a lawyer. The law Malcolm say he has a slip person name. One day he's saying, okay, so y'all guessing it was his lawyer. Okay, let's hold that pen. Y'all finna find out. Y'all finna find out who snuck those pictures to him. Let's keep reading. 68. December 3rd, BSO main jail command received communication about a social media post made by Melly on his IG Instagram account containing a photograph of Melly in the jail. Now they mad now. They like, how you get a photo in the jail? The post referenced command staff names. That's why they really mad. They don't want their names out there because they ain't on the up and up. And alleged mistreatment in the jail. The post caused serious concerns about the possibility that, y'all being found out, about the possibility that Melly had access to a cell phone. A search of Melly in his cell was conducted, and guess what? Negative results for a potential cell phone. On February 7th, a letter was discovered in the BSO mail marked confidential legal mail that was returned by the United States Postal Service, USPS, due to a non-existent address. All right. Okay. Sending a letter to a non-existent address is a known method used by inmates to communicate with one another to conduct criminal activity while in custody. Now, this is interesting. I will point that out. This is interesting that you send a letter to somebody and you put their information as the return address. So when you send a letter to a fake address, they send the letter back, but instead of the letter coming to the person that wrote it, it'll go to the person who name is on the return part. That, they come up with all type of slick stuff in jail. In this method, the inmate sending the purported legal mail uses the name of the inmate that he intends to receive the letter as the letter sender and sends it through USPS to a non-existent address, hoping it is returned to the inmate listed as the sender of the letter. Because the letter is purported to be legal mail, it is intended to be delivered to the other inmate without security staff reading the letter. Now that is crazy. That is crazy. I wonder if that works in real life. Nobody better not try it and get yourselves in no trouble. But I'm just curious. If you write a letter and you have the return address as the person you really wanted to go to, and you sending it to like a fake address, but when it's returned to sender, it's not going to come back to the person that wrote it. It's going to go back to the person whose name you put in the return box. So I'm not sure how would they be able. Yeah, I'm not sure how they'd be able to flag that unless they can tell where the letter's coming from, what city. But yeah, that's crazy. They come up with all type of stuff. Okay, because the letter is reported to be legal mail, it is intended to be delivered to the other inmate without security staff reading the letter. Right. So if I write a letter and instead of putting my name in the return box, I may put Law Malcolm information. I'll mail it off to a fake address. Of course, the address don't exist, so they're going to return it to sender. They're not going to really return it to me. They're going to return it back to Law Malcolm because I put his name in the top left-hand corner as a return box. I mean, yeah, this is, you know what, Miss Susan, you're going to be hiring me pretty soon. Don't do that. Yeah, he's being targeted. I agree, Chris. I agree for sure. All right, let's keep going. Let's keep going so we can find out who gave Melly some inappropriate pictures. She said put the same name as the sender and the receiver without a stamp and without the letter gets delivered. Right? Wouldn't that be crazy? They're gonna return it back. They're gonna return it to the person who wrote it and say, you don't have a stamp. You forgot your stamp. I mean, because if you're gonna do that, why even put a stamp on it? I mean, right? It's yeah, because I'm sure people have mailed off letters and they forget to put a stamp and they send it back to the person that mailed it. But in any event, let's keep going so we can find out who the culprit was, because something is, what did it say? Something wrong in Denmark. Some fishy going on. So let's go. The content of the letter was reviewed, and security staff determined that the letter was sent from inmate. It was sent from inmate Alexander, also housed in the main jail bureau. And the return address of the letter was to Melly, housed in Unit 5C2 cell. Alexander wrote that he was sent to confinement for helping Melly contact his friends and family. So Alexander was sending word to Melly like, "Hey, Melly, they found out I was helping you, so I'm in solitary confinement." And Melly at the time had no phone privileges due to witness tampering charges. This is a lot of reading. Alexander told Melly that he still wants to help him. Alexander said, "I'm still gonna ride for you. I still want some of that commissary." So he said, "I'm still gonna help you." Alexander received a DR regarding this matter. On February 15, 2023, inmate Taylor Carrington made a call to Aaron Barnett for petitioner. On February 17, 2023, petitioner received a DR for conduct which disrupts unauthorized use of telephone, disobeying facility regulations while housed in Unit 5C2, based upon the phone call that petitioner had Taylor make on his behalf. How y'all know he had him make it on his behalf? Through an investigation, it was discovered that Melly placed a note under his cell door to provide it to another inmate who was on their allotted cell time. The inmate placed the note under Taylor's door. So here we go again. You got 2, 3, 4 inmates, different inmates. They saying doing all this on behalf of Melly. Taylor was observed on security cameras making a phone call for Melly while reading from the paper he was provided. The phone call was made to Jamie King, Melly's mother. The DR was thrown out. Wow, we got one that was not guilty. What? The DR was thrown out due to a technicality of the infraction time being documented 1 minute different from the narrative. I mean, I don't see an issue with that. If somebody called Melly's mother or they want to tell Melly's mom how he doing in jail, then you can't say automatically Melly ordered that person to call for nefarious purposes, for bad intentions, to circumvent the jail. They looking out for each other. September 1st, after receiving information that inmate James Howard was in possession of kites, which are letters, notes written by a petitioner housed in the adjacent unit, requesting that Howard make unauthorized calls and or contact others on behalf of petitioner. A search of 5C3 was conducted. Incident report for inmate James Howard's possession of kites attached. Okay, several handwritten letters, notes suspected to be from Melly. How y'all don't know? Y'all don't know his handwriting? Suspected to be from Melly were removed from Howard's cell, and photos were taken of phone numbers suspected, here we go again, to be associated with Melly. So this is a lot of speculation. Y'all use suspected twice in this long in this long paragraph. All right, so y'all don't know for sure. On the same day, information was provided indicating inmate Terrence Mathis may also have in possession of kites, may also have in possession of kites written by Melly. There's something missing right there. The kites were given to Mathis in the past to make unauthorized calls and to contact others on behalf of Melly. A search was conducted on the cell assigned to Mathis, and additional kites were removed from this cell. The kites gathered from the two cells were collected and handed over to a BSO Special Investigations Division, SID, detective who received them September 28, 2023. Okay, here we go. September 19th, BSO Sergeant contacted the Department of Detention, Bureau of Investigation and Projects. Goodness, this is too much. Lieutenant, to advise him that he and his team has been communicating with an informant. So we got another informant, y'all. They love these informants. When they don't have evidence or a real person to blame it on, all you gotta do is say it's an informant. It's a confidential informant. Yeah, that don't sound nefarious at all. Okay, the BSO SID sergeant informed the BIP lieutenant that current inmates YNW Melly, now they call him YNW Melly. What was that about? Bot, T-Man, and Stunner are currently selling paper dope laced with fentanyl and abdominal fluid to Molly. What? Let's see. Tamale. What that mean? Maybe in Molly, which is sprayed into the male and later used by sniffing it, smoking it, or placing it over your tongue and letting it absorb. Goodness, the hell? What the hell? Let it absorb. According to the informant, these inmates are receiving the lace mail from an unknown outside source and selling it to other inmates in exchange for commissary money and food. Now that's crazy. Oh, and another fun fact about the sheriff. When he applied for a job before he was a sheriff, he admitted on the application that he used to use LSD. It's a hallucination drug. And, obviously he admitted that he used LSD. They didn't give him the job. So every other application after that, he learned. He's like, oh, I better not confess to using a legal drug when I want to be the police. So he started denying ever using that drug. And that's another thing that the Ethics Commission, they investigated him for lying because they had that other application that he filled out back when. So I just found that that's interesting that drugs are moving in the facility and the drugs may have similar effects as the drugs that the sheriff himself used to be on, according to his own application. Oh, thank you so much, Stephanie Lane. It's really kind of you. Thank you for tipping the channel, Melly, aka Killer Clown. Hey, well, the trial so far, they came 9-3, 9 for manslaughter, and 3 not guilty. So that's yet to be seen. But we gonna stay on top of it. I do plan on covering that trial for sure all the way through. But thank you so much, Stephanie. I definitely appreciate you always supporting the channel. That's really kind of you. So let's keep going. Let me see if I can. All right, because here we go. The informant, confidential informant, further advised that he has personally bought the lace mill from inmate YNW Melly, T-Man, Vought on several different occasions. According to the informant, he advised that YNW Melly, aka the petitioner, is a current gang member. Oh, here we go now. Now he a gang member. And guess who he rep? He repped the blood set. This sound like YSL, so he might have been talking to Slime. And that YNW Melly was providing him and other inmates with narcotics. Oh, raise y'all hand if y'all believe that. Y'all laughing at Stephanie. Y'all laughing. Right, y'all know Stephanie gonna have some fun if she don't do nothing else. All right, y'all, let's keep going. They said now we got a confidential informant. Not only saying that Melly selling dope, selling drugs, but he also put him in a member as a blood set. Now, this confidential informant that came and told y'all all this, y'all second confidential informant so far. Okay. September 22nd, 2023, BIP deputy spoke with the confidential informant to obtain information on any paper dope being brought into the jail. The informant stated that Melly, the rapper, aka YNW Melly, aka Jamel Demons, currently had a yellow document with the mentioned lace paper dope. Okay, so he got a document. Let's go find it. Deputy and a BIP sergeant responded to the main jail unit and conducted a thorough, what word is that? Thorough search of Melly's cell and legal paperwork. Guess what? The mentioned yellow papers with drugs were not located. Okay, so now we know y'all confidential informant ain't reliable. So are y'all going to reverse y'all actions now because y'all confidential informants ain't? So if this informant lying, maybe the other informant was lying about the handcuff key. Maybe it's the same informant. Maybe it was no such thing as no handcuff keys. Y'all just stopping him from being with his attorney. All right, let's keep going. October 3rd, a probable cause affidavit was submitted for witness tampering by petitioner and his accomplices in a capital murder case. And we found out, see, this was wrote before we found out, but recently we found out that the accomplice who they are accusing Melly of tampering with a witness with is his own attorney, Raven Liberty. Y'all, you can't make this up. You can't make this up. Oh my God. Okay, here we go. Probable cause for petitioner separate witness tampering criminal case. Okay, this case is docketed. We got that. Petitioner's co-defendant in the murder, Cortland Henry, who was released on monetary bond. See how Cortland Henry get a bond, right? And he's a co-defendant with the same charges as Melly. He was released on a bond, but not Melly. Melly's been in there for 6 years. But since they're accusing the co-defendant of tampering with a witness, he was remanded into custody with a no bond status. Now he's in jail with Melly after being charged with witness tampering for sending and receiving phone calls and messages to Demons Melly to conspire to harass scare, and intimidate the witness for their pending homicide charges. His case is pending. Yeah. So you can't say, oh, he's charged with capital murder. Everybody in this county that's charged with capital murder do not get a bond, except the fact his co-defendant, who was in the same car with Melly, got a bond. And y'all saying this is equal justice under the law? The probable cause affidavit for the witness tampering charge states that the detectives became aware of Melly's witness tampering activities when detectives reviewed jail evidence. Wow. And witness testimony that indicate Melly and his accomplices were introducing lace paper into the jail while investigating Melly's gang activity. Now he's a gang member, y'all, because a confidential informant said he was. Now he's a gang member. While investigating Melly's gang activity, detectives reviewed all the jail calls made to Melly's girlfriend and to Jameson, who had been facilitating the three-way calls for Melly while he was in custody. Through this sophisticated system, Melly was able to speak with persons outside of the jail, including with his co-defendant here in Cortland, who the trial judge ordered he not speak with, as well as petitioner's girlfriend and others. Petitioner's Melly's primarily used PIN numbers of other inmates to call his co-defendants and other individuals outside the jail, or had other inmates make those calls for him. April 19, 23, an inmate on behalf of Melly called Melly's co-defendant here in Cortland and told him to tell one of the witnesses to Melly's current homicide case to shut the F up. Tell him to stop talking about that. And Cortland replied to the inmate calling on behalf of Melly. You don't know if he calling on behalf of Melly. You assuming that he is keeping the witness away from court. So they're saying that Cortland said to a third person, not Melly, that he's going to keep the witness away from court. Detectives also discovered other recorded conversations between Cortland and inmate Mathis concerning narcotics smuggling in the jail on paper documents laced with drugs. Okay, so I see a tampering case. If y'all have it recorded, y'all can build a tampering case against Cortland and the person who Cortland was talking to. But I'm not seeing how y'all can tie Melly into that unless the person that Melly was allegedly instructing the cellmate testify against Melly and say, hey, Melly told me to say that. But without that, it's really hard to link Melly into that tampering case without Melly actually being on the phone when you have other people that supposedly are speaking on behalf of Melly. For all we know, these could be, y'all say he's in a gang. They could be showing allegiance to Melly and they doing this on their own free will to make sure Melly don't get in trouble. Y'all can't say for a fact that Melly was directing them to tamper with a witness. So, that'll be fought later on. Petitioner was charged for his criminal action while in custody for the following charges: directing the activities of a criminal gang, because somebody said he was a blood, we don't know who, informant, solicitation to commit tampering, and conspiracy to commit tampering. Those add-on charges are still pending in court. Okay. On March 29th, the BSO Internal Affairs responded to Melly's housing unit. A BSO deputy and detention technician assigned to Melly's unit were what? Relieved of duty for what? And suspended after it was discovered they were providing Melly contraband, including what? Lewd photos of unknown females. Come on. Wait a minute. Y'all trying to say his lawyer was supposedly supposed to sneak pictures in when it was your own deputy and detention officer who were relieved of duty, fired after it was discovered they were the ones providing the contraband and lewd photos of unknown females to Melly. Come on. Come on. You can't make this up. You can't make this up. You can't make it up. The whole time y'all trying to come after his lawyer, and y'all got a fox in the hen house. 2 foxes. And I ain't talking brown. Come on. Wow. Y'all. This should be enough. This is enough for me. This should be enough for a judge. Like, come on. Right. And if they're bringing in the lewd photos, it can be assumed that, and just think about it. If he has these people risking their careers, their livelihoods, bringing in, photos and contraband stuff he's not supposed to have, they officers. Hell, he could have got a handcuff key from them. Why he had to use his own lawyer to go find a handcuff key? Hey, don't close that cell all the way. Leave it crack. But be for real. I mean, how even if he did escape, how far he gonna get before they find him? Oh, let's keep going, y'all. This is when I read that, I was like, I know you lying. March 29th, another search was conducted in Melly's housing unit. Leave that man alone at this point. Papers containing pictures and 2 kites were discovered in Melly's cell. A BSO, SID detective, and sergeant were advised of the kites found. As a result of the events and manipulation of staff, coupled with the many previous security breaches and alleged witness tampering, Melly was relocated to the Paul Ryan facility to a housing pod to be housed by himself. So he had to be housed by himself because he was manipulating your staff, who are the trained professionals who know better. Right. Somebody said they the ones need to be they need to talking to, not they need to be counseled. So they gonna counsel Melly. I mean, at the end of the day, Melly is an inmate in custody. The professionals have a position of power and authority over Melly. So it's their responsibility to not be manipulated by someone under their control. That's almost like a teacher saying, "Oh, I wasn't gonna talk to that. I wasn't gonna date the student, but the student came on to me, manipulating me." What? And you sit up here, a grown woman, grown man. And you talking about the child displayed at you, and you the one in control. Right, Mr. I really like this. They just keep telling on themselves. And we got to remember, this is what they wrote. This is not Melly's lawyer trying to make them look bad. This is their words. And this is just what we know. Imagine the stuff they not telling us. Let's keep going real quick. Let's wrap this up. Because somebody say I don't need to hear no more. I think we're almost done. A lot of this stuff is just the law. We ain't got to go through that. As a result, okay, yeah. So they moved Melly to a cell by himself. April 13, 24, Melly was counseled. He was counseled for asking personal questions to staff about what the staff member would do if he had $1 million. Okay. I mean, what does that mean? I mean, it seemed like they were having a conversation. Was Melly trying to bribe him to take $1 million, or were they just having a casual conversation like, hey, bro, I'm in jail. I had it all. I had $1 million. What would you do if you had $1 million? If you were on the outside, I'm a rapper. I did this. I did that. I don't know. That's not enough for me. Number 81. Melly was relocated back to the main jail and housed in a unit by himself on April 12th. To date, Melly has had 249 visits from his attorneys and investigators. In sum, Melly has utilized other inmates, BSO, BSO staff, his attorney, and other individuals in his circle to assist him with facility rule violations and security breaches, and most importantly, the abuse of his phone and video visitation privileges to the point that no other alternatives exist other than to restrict access to both privileges for the security and safety of the facility and for the safety I guess you're missing a word, of other individuals outside the jail, the witnesses to his homicide charges, whom Melly has sought to silence. Y'all, come on. It's the writing for me, though. This writing is all over the place. Yeah. There is also evidence that petitioner Melly has been involved with smuggling / selling drugs in the jail, and through his mother and girlfriend, payments have been made to other blood gang members for illegal activities. First of all, I don't believe this. And I'm going to tell you why. I don't believe this. Because there is also other evidence that Melly had been involved with smuggling. First of all, if y'all had the evidence, we on number 85. It may sound good to say, oh, there is other evidence. There's also evidence. What is that evidence? What is that evidence that Melly was involved in smuggling and selling drugs and payments to the other blood gang members for illegal activities? Because I can guarantee if y'all had that evidence, y'all would have wrote it down. Y'all wouldn't have said there's also evidence. Y'all would have said, we caught Melly in the act. We found on his person. He had drugs smuggled on his person. We caught him selling drugs. But, you know, in a court filing, to make it sound good, there is also evidence. That's what they'll put. I don't believe that for a second. Melly has not only violated internal jail rules, jeopardized the safety and security of operations, but he has committed additional crimes, which he has been charged with, including tampering with witnesses and other charges. And I've seen y'all evidence for these other charges, and y'all, it's not gonna hold up. I'm tearing it apart, and I'm just reading it 30 seconds. So I know his lawyers are gonna really cut it up. Even though he is a high-risk administrative inmate, Melly is treated like a general population inmate for housing purposes, where he is allowed out of cell time during Bravo and Charlie shifts, just like other general population units. Melly has free reign to use the television and shower during his time out. Exhibit 7, okay, petitioner is getting recreation at the same schedule as other administrative inmates as weather permits. He is allowed to send and receive mail as any other inmate with no restrictions on regular or privileged mail. Petitioner's attorneys, Melly's attorneys, with the exception of Miss Liberty, they do not like her for whatever reason, have normal, non-barrier attorney visitation access. Miss Liberty, big space between there, Miss Liberty also is permitted to visit with petitioner in the same manner as other attorneys, but for legitimate security reasons, it is restricted to barrier visits. So it's not the same manner. It's not. Melly's only restrictions on privileges are his phone and video visitation use. The restrictions were placed for legitimate safety and security reasons based upon pervasive, documented violations of jail security rules. Further, Melly may communicate with family, friends, and his attorney through written correspondence. Like he in a war overseas and you can only write letters. Let that man call his folks. Due to the numerous incidents described above, which are only account of some of the more serious disciplinary and security incidents involving petitioner, his current conditions of confinement are objectively reasonable and related to security and safety concerns, and Melly's claims to the contrary raised in Melly's petition are against the sheer weight of the evidence that justifies such security measures and cannot be described as anything other than vexatious. Yeah, that word again. Accordingly, the petition should be dismissed or denied as discussed in the ensuing memorandum of law and argument. This is, you know what? And then here they just kind of go into some law. They basically saying that he did not exhaust his mandatory state court remedies. We talked about that earlier. You got to go through state court first. They're saying that this should be denied because Melly didn't go through all of the courts in the state before he filed in federal court. They said he only went through the trial court, but he should have went through the state court, then the trial court, which is the local court, then the appellate court, and then the Supreme Court on top of that if the other two lower courts didn't rule. But that's a lot. I mean, you got to go through all of those courts and then wait to get to federal court. He'll be there another 6 years. All right, let's go. They also saying conditions of confinement, access to a lawyer, or an order, appealing an order denying monetary bond for pretrial detainees are subject to interlocutory appeal. So they basically saying you should have went to the Florida appeals court, like I just said. Likewise, filing a habeas corpus petition in state court is the correct mechanism under Florida law, not filing it in federal court. So they're saying throw it out. And then they got a little discussion in here. The petition alleges the petitioner has continuously sought relief in state court, and the state court has been useless. They have been useless. They couldn't find non-restrictive means to let him visit his attorney. That includes searching him, make sure he doesn't get a handcuff key, and then putting him back. But of course, he don't need a handcuff key from his own lawyer when we got your own sheriff's deputy doing the job for him. I mean, come on. Let's be for real. Yeah, he's high risk but treated normal. All right, let's see. So they're basically, I'm gonna kind of skim through this so we can wrap this up. There has been no notice of appeal filed from any trial court on matters raised in the petition, nor any extraordinary writ filed in trial court or in Florida. Okay, so yeah. Give me a second right quick. Okay. In fact, there have been appeals in the trial court proceeding by Melly in the state of Florida, including. So basically, they're saying that Melly was charged with the capital murder. They challenged the death penalty. They challenged the admissibility of evidence. They challenged motions to suppress. They wanted to preclude the state from seeking the death penalty. So they said they fought all this other stuff with the appellate courts, but they did not file this particular lawsuit, this writ with the state court. So they're saying that they know how to file appellate briefs. They did it with all these other cases. So why didn't they do it for his treatment at the jail? They say even though the state and Melly have taken the opportunity to hotly contest the issue of the death penalty and other pretrial motion practice issues, it is evident that Melly has failed to file any appeals or any extraordinary proceedings in the Florida appellate courts directed at either challenging the September 27, 2022 trial court order denying petitioner's motion to remove visitation, communication, or interaction restrictions, or any other of the allegations in the present petition. Because petitioner has failed to exhaust his state court remedies, it should be dismissed. This Melly's lawsuit should be dismissed. Okay, and then they quote another case here, Younger. a younger case. That's the name of it. And what does the Supreme Court say in Younger? State criminal proceedings offered a sufficient forum for the plaintiff to raise his constitutional defense. Staying from here, the plaintiff's claim. So basically, what they're saying is, if the state court can do the job, don't involve the federal courts, because if you involve the federal courts will interfere with the state's independent authority to grant bond or deny a person from having a bond. So the Younger case is basically saying, if the state courts can handle it, let the state courts handle it. And I'm just summarizing this to make it shorter. In order to decide whether the federal proceeding will interfere with the state proceeding, the court looks to the relief requested and the effect it would have on the state proceedings. The relief sought need not directly interfere with an ongoing proceeding or terminate an ongoing proceeding in order for Younger to apply. So it's three questions they said the court would ask. The question is threefold. First, do the proceedings constitute an ongoing state judicial proceeding? That is true. Melly's on trial for capital murder, so that was a check. Do the proceedings implicate important state interests? Yes, the state has an interest in protecting the public, right, from criminal activity, alleged criminal activity. And third, is there an adequate opportunity in the state proceedings to raise constitutional challenges? Now, that's the issue. I think they tried to raise it with the trial judge. It's been years, no contact. They tried it, it didn't work. So now I don't think number 3 applies. It wasn't adequate opportunity, so that's why we in federal court. All right, so they just kind of got some more legalese here. There cannot be a greater example of interference with a state court proceeding than granting the relief that petitioner is requesting in this case, namely pretrial release for pending capital homicide charges in which petitioner faces the death penalty. Granting such relief will be directly contrary to the order of the state trial court. The order of the state trial court order that petitioner be held in BSO's custody with no monetary bond. So they're saying that it's interference. There cannot be a greater example of interference if the federal court was to step in and stop the state from conducting their business. They said it can be no greater example. Just like they said it could be no better fact pattern of Melly being disruptive in the jail. You can't find a better example. Oh my goodness. Okay, see. Okay, so this is kind of like a lot of legalese. I'm not really seeing nothing new here. Case. So Melly's requesting to be released while being prosecuted for a capital case. Here they go again. There cannot be a greater example of undue interference in a federal court ordering the release of a pretrial detainee held for murder charges on no bond. Yeah. And if I was the federal court, I'll say, okay, well, y'all gave bond to his co-defendant, so what was the distinction if they're both accused of the same exact crime? So I really don't see nothing. They're just summing it up with a lot of law. Okay, crew. Okay, yeah. Additionally, is someone follows crew me. Discussion, the restrictions on position of phone and video for legitimate security clearance. Okay, something issue here. Okay, as discussed in significant detail above, within 1 week of petitioner arriving in BSO's custody. Well, earlier y'all said it was 1 month, yeah, but we'll go with 1 week. Okay, he started breaking jail rules. He was involved in physical altercations I've only heard of one fight that they talked about, but physical altercations with inmates and both verbally and sexually harassed female staff. More importantly, Melly also abused his phone and video privileges constantly, which required them to revoke. Okay. Melly called his girlfriend over 3,000 times while using other inmates' pens to try to avoid surveillance to his calls. Okay. It turns out Melly was using this communication network between his mother, his girlfriend, and others, both inside and outside of the prison, including his co-defendant here in Cortland, in his pending homicide charges to facilitate a wide range of illegal activity, including tampering with witnesses outside of the jail who were set to testify in petitioners Melly's capital homicide case. Okay, Melly used BSO phone and video privileges to instruct individuals outside of the jail to threaten and silence these witnesses, for which petitioner is now facing criminal charges. Now, see, I don't even know if we got to that part that he was instructing individuals. He was threatening them and silencing, threatening and practically silencing them. The other dude just said they told him, "Hey, stop talking about that." Not stop talking about that, or we gonna get you next. Now that part is like the threatening, the silence, and that's even if Melly was the one that was directing it. And we don't have no proof that Melly was directing it because it was other people that allegedly was calling on behalf of Melly. And through his mother and girlfriend, payments have been made to other blood gang members. I'm interested, where are those payments at? Melly has been using the phone system as a means to accomplish these goals. She allowed, Raven Liberty allowed non-attorneys to use her login credentials. Okay, we got that. They summing it up. Melly, in his own words, stated, "I should get a DA burner number from my attorney today," and stated, "When I do, fam, don't ever call that bit with your pen." Okay. Yo, and another thing, when you writing a paper, and this is just like a little side note, when you writing a paper and you summarizing, don't ever put nothing new in the summary or at the end. The summary should be only stuff that was already discussed in the beginning, because a lot of judges will skim over this. They're not going to read it again because they know you summarizing. So this is my first time seeing this. Petitioner stated, "I should get the burner number from my attorney today, and when I do, fam, don't ever call that bit with your pen." That should have been something y'all said at the very beginning, not on page 25 or 31. Y'all introduce it for the first time when you closing out. It's a Melly also said, "Always use someone else's, and you're gonna be the only one with the code and the number." Clearly, if Melly were to have access again to the phone and video visitation, he will continue to break the jail rules. Okay. And circumvent security rules. Melly's own counsel even agreed that petitioner Melly violated jail rules. Now, I know his lawyers got something to say about that. I know they said they ain't agreed to nothing like that. I mean, because that's why they were fighting it. They filed the motion to fight to be able to see their client. And some, Melly has been continuously violating jail rules since he stepped foot into the jail and has committed new crimes while in BSO's custody. So they're saying the specific restrictions of Melly's phone and video were implemented to curtail not only further efforts by Melly to criminally tamper with the witnesses for his pending capital homicide charges. They're going to keep saying that. But also to prevent Melly from engaging in drug smuggling, which I have no proof of, and other well-documented criminal activities with his fellow blood gang members. Now, right, now they hyping it up. Now, one confidential informant said he a blood. Now all of a sudden, oh, he a blood gang member. He gang activities. He directing the gang. He's taking payments. Where all this evidence at? Preventing criminal activities is clearly a legitimate goal, and these restrictions are reasonably related to that goal. Okay. Additionally, to the extent Melly contests that he did not tamper with the witnesses for his capital homicide charges uh, via BSO's jail system or engaged in drug smuggling or gang activity, he is barred by Heck v. Humphrey. Okay, he is barred by Heck v. Humphrey, barred from doing so, as he is currently being prosecuted for those charges. Oh my. See, lawyers today are relaxed. This is too sloppy. This right, the run-ons, the never-ending paragraphs. The I'm telling y'all, some judges don't play that. The restrictions on petitioner's access to one of his attorneys, Raven Liberty, are for legitimate concerns. Okay. They don't. Okay, it's already discussed. Glass barrier. Now that's an interesting sentence right here. If Melly defense team chooses not bringing Miss Liberty, then BSO does not require a glass barrier or any barrier to Melly from interacting with any other of Melly's lawyers, counsel. So what they saying is, if the defense team, and why they put it in quotation marks, y'all catch that shade? The defense team in the quote, like they're not real, chooses to bring Miss Liberty with them, not bringing Miss Liberty, then BSO does not require a glass barrier. So what they said is leave her at the house. Y'all want to bring that woman with y'all. If y'all don't bring her, y'all don't have to go behind this glass and talk on the phone. Y'all can contact Melly all y'all want to. Leave her at the house. But y'all choosing to bring her. That ain't how they work. Every attorney may have their own portion that they bring to the table for the case. Because if they can leave Miss Liberty at home all the time, then she wouldn't even be needed on the team at all. She's on the team for a reason. So you can't pick and choose which lawyers could come, or should they leave her at home, or what are they talking about? Why y'all be talking so long? That ain't none of y'all business. They say Melly is not required to use the bond room. Additionally, Melly claims that he had not been allowed to see his counsel or in a private setting. They say that is quite frankly a misrepresentation. No, that's not. I mean, that's not. The judge said it himself. The judge told y'all they need privacy. Move them from the bond room. Move them to another room. So, and if that was the case, a bond room is obviously public, people in and out, it's not private, then that's not a misrepresentation. And misrepresentation, call a lie. As previously discussed, BSO received information from a confidential informant. See, they still going back to this lie with no proof. That petitioner's attorney, Melly's attorney, was going to attempt to smuggle 2 keys to handcuff. Wait, what? Now look at this sentence, y'all. Previously discussed, BSO received information from a confidential informant in BSO's jail that petitioner's attorney was going to attempt to smuggle 2 keys to handcuff to petitioner and inmate Lewis to help them escape. Was going to attempt to smuggle 2 keys to handcuff to petitioner and inmate Lewis to help them escape. Goodness. Oh man. When petitioner and inmate Lewis cell was searched, drug contraband that was confident that the confidential informant indicated was present was found. Okay. I can go to Fulton County right now and say, hey, y'all gonna find some drugs there. Y'all gonna find some knives there. Y'all gonna find some extra commissary there. Oh, and y'all gonna find some handcuff keys there. So if they go to the jail and they find everything but the handcuff keys, they can say, well, part of what Talk Their Law said was true. They found the drug, they found a knife. So if it was true about that, it must be true that the handcuff keys are next. That's what their theory is. So that's what they genuinely said. When Melly and Inmate Lewis' cell was searched, drug contraband that the confidential informant indicated was present was found, which provided veracity to the information. Likewise, a recorded relay call on September 15th between Petitioner Melly and his girlfriend. Y'all keep saying that it was Melly. It wasn't Melly on the phone with her. See, they misleading when they say this relay call. It was a third party or fourth party that was on the phone. And y'all know how the telephone game work. You say one thing, by the time we get to the end, it's completely different. And they're saying that when Melly allegedly spoke with his girlfriend, spoke of Miss Liberty conspiring with Melly to smuggle in contraband, photographs to Petitioner. And that turned out to be a lie, because who smuggled in the photographs? It was a sheriff's deputy and a detention officer, or whatever name they try to give it, fancy name, detention technician, I think they used. It's crazy. Preventing an individual from smuggling contraband into the jail is clearly a legitimate goal. Okay, cruel and unusual. Okay, they said it's not cruel and unusual. Okay, he's in an housing pod by himself. A housing pod consists of 4 or more cells, with large common areas called a day room, which has a TV, a phone. Okay, all the stuff we already covered before. We know that already. Okay, he placed thousands of calls. See, they summing it up. Removing position direct access to inmates, prevent him from having access to their phone, pens, and kites. Okay. Now we did concluded 10 times. Like we did concluded 10 times. Now let's wrap it up. The conditions of confinement imposed Petition were done in response to security. Okay. So they said it was legitimate concerns. Okay. All right, y'all. This is pretty much all of the legalese, and they said it went timely. A 1-year statute of limitation applies to the filing of habeas corpus petitions. They're saying it was late. The limitations period runs from the date on which the judgment of conviction became final, which obviously hasn't been a conviction. So number 1 doesn't apply. And that's an unconstitutional impediment to filing was removed. A new retroactively applicable right was initially recognized by the Supreme Court, or number 4, facts supporting new claims could have been discovered through the exercise of due diligence. Whichever date is latest. The only issue with this is it's still continuing to this day. He doesn't have contact with the attorneys. So, I mean, the limitation clock is still rolling because it's still happening right now. He still doesn't have his phone privileges and things of that nature. So you can't say that he's too late. I say he has a year from whenever y'all stop doing it. It say Melly would have known the factual predicate of his claims in the present petition for a writ of habeas corpus by the latest on September 22. Why y'all say that? The date there was a state court hearing on petitioner's motion to remove visitation. And the 1-year statute of limitation would have accrued at that point. It started. I don't know if that's true though. So wherefore they want them to deny Melly's lawsuit, dismiss his application for writ for habeas corpus, and be denied attorney's fees. Because of course they're not going to pay attorney liberty. This is a lot. Oh my God. Yo, we made it. We made it through. We made it through 3 hours. We made it through 3 hours. And this is his. These are his federal attorneys, and I think this man may be like a mayor or something in a city in Florida. Let me Google his name. What's his Michael? Let's see. Oh no, he was acquitted. So it looked like he probably had something going on. Okay, well, it looked like he had something going on himself, and he was acquitted, but the governor removed him from office. The former governor of Florida. This called me to drink. Y'all right? Anybody got something they want to add before we convene? Before we convene for today, because this here is insanity, to say the least. This is crazy. I had it muted. I definitely appreciate y'all coming on. This is crazy. And this is only the beginning. This is only the beginning of their fight. He says, Michael. No, absolutely not. He is the lawyer that was served. He's the lawyer for Melly. Now, let's see who wrote it. Let's see if we can see who wrote it. No, he's a lawyer for Melly. See, he was served. He's on the service list. They have to service to the other side. I hereby certify that it was served. Yeah. But it looks like the person who wrote it may have been this person here. Yeah, these two. Respectfully submitted, these two. I called one attorney T, so I wouldn't butcher his name, and then we got another T. It's two attorney T's. Yeah. She say, "Don't stay away so long. We needed this entertainment." No, I'm not. I'm not. I got some because I had most of my cases front loaded at the beginning of the year, so now I have a little bit more time coming up in the upcoming weeks. But no, I ain't gonna stay long. I'm not gonna stay away long. I'm not gonna stay away long. This was good. Thank y'all. Law Malcolm, you bring me a case. Bring me a case, Law Malcolm. Bring me a case. Bring me a case. He said we always showing up with rapper cases. You gonna be mad if I what's buddy name? Rihanna. Y'all know Rihanna. I guess boyfriend. Y'all know his trial coming up. Law Malcolm gonna have a fit. We might, matter of fact, we might cover that one. We're gonna cover her boyfriend or father of her children or child. The judge say, wait, are they married or what? And the lawyer said, no, they common law. He said, what do I call her? Judge, it don't matter what you don't even need to really bring her up because she ain't got nothing to do with that case. Y'all want to watch that one? And do y'all think Rihanna would be at the court to support her man? Thank you to the man. Y'all think she gonna be at the courtroom or what? Okay, she said yeah. Okay. All right, yeah, we're gonna make, and I think that one start, I think next week. He said, you know, she's going to be there, right? And I think the judge, he wanted Rihanna's information relationship so he can tell them, like, hey, she's a major superstar. Y'all may know her, but y'all shouldn't use that as a reason to find him guilty or find him not guilty. It shouldn't matter. She said, I was not expecting this laugh today. Yeah. I remember when we did the video, I had said I was gonna come back and find the lawsuits, and just I didn't realize it was gonna be extended. But hey, thank y'all for sticking in here with me. How your mom being? Tell her I said Happy New Year when you get a chance. Tell her we missed her. We ain't see her name pop up in the chat in a minute. He say the rapper lawyer. Here you go. But yeah, I think that'll be an interesting case because apparently, ASAP Rocky and his, I don't even know what you would call it, colleague or his employee, somebody that was signed underneath him, got into a dispute. And from my understanding of the dispute, you had ASAP Rocky and you had the other guy who got into a dispute. Supposedly, ASAP Rocky was supposed to fly another friend's body back into town, but he didn't fly the body back in. So the friend talked about Rocky bad, about, hey, you didn't follow through. You're supposed to take care of the funeral, bring him into town. Whatever the case may be, they got into it. And he's saying that they met up. I don't know why y'all meet up for if y'all got into it. I mean, that's the recipe for disaster, but they met up. And he's saying Rocky pulled a gun and shot towards him, and it grazed his finger, grazed his knuckle. But he didn't go to the hospital, and he didn't go to the police until later on. And when he did go to the police, he showed up with a lawyer. So it's just crazy, all over the place. All over the place. I'm like, what? If somebody shot you, you know why not go to the hospital? But it's a case almost like the Tory Lanez and Megan Thee Stallion. Somebody shot, but it's inconclusive. Was it like? Well, at least we say it's inconclusive. Where is the bullet hole? Somebody shot. Where is the bigger hole? Your finger grazed. Is it grazed because you punched? You were trying to punch him, or did you punch Rocky, or what? What happened? And then on top of that, I think they said that he reached out to Rocky's team, trying to get paid. I'm like, wait, what? I mean, if you wanted somebody to shoot you, I mean, a normal person get medical attention right then and there that night, and most people will call law enforcement. And I mean, why not call law enforcement? I mean, because clearly you file charges and you're testifying. You already testified at a preliminary hearing, so it's not like that. Some people in the streets don't fool with the police, but apparently, that's not him. So why not call the cops when it happened, unless it gave you more time to potentially develop a story? Now, I'm not saying that it didn't happen, but I'm saying it's shaky. It's shaky. Something don't sound right when I was hearing the story. Like, nah, something else didn't happen. Somebody said they losing their fingers and their toes. Oh, that's y'all funny. The fingers and the toes. Ain't nothing safe. Nothing is safe. Yeah, but I don't know. I mean, we gonna see if we can get the real story and we can break down what really happened. But he talking about, yeah, he was mad that he called Rocky out, but you could tell Rocky was mad, and Rocky was like, you heard it in his voice, he was on something, but you met up with him after that, and not only that, but you said that I could tell in his voice that something wasn't right. He was sounding like he was trying to do something. So I didn't tell him what hotel I was in. I told him a different hotel, so he couldn't see me walk out the hotel. And then I walked over there from the hotel I was at. What? I mean, whether you walked out your own hotel or you act like you were staying at a different hotel, you went there. Now maybe he thought he was gonna just fight Rocky, and I think it looked like he took the first punch. It looked like he took the first punch towards Rocky. Let me see if I can pull up just so we can get a preview of what's to come. Rocky. All right, y'all. Let's see if we can do it like this. Let's see what TMZ got over here. They got it loud enough, don't they? Oh. Okay, so they said that's the gun in Rocky's hand. Hold on, let me go back. Let me see. See if we can see who started what. See, I don't know. It just looked like he walked up like he was on some. All right, let's see. You got man. We can't tell who and who what. Right. So yeah. Yeah. So I don't know. And that's why Rocky's lawyer is saying that the evidence is inconclusive. I mean, because so far all we got is you know, a blurry video. Let me see. I think did he make a statement? Yeah. I don't know. I don't see it. But I know he was on the stand his friend was on the stand. Rocky shooting. Let me see. Yeah, that's what he said. He said Rocky turned around and shot me. Childhood friend testified about his Hollywood shooting. So this gonna come down to witness credibility. And if there was a lot of people out there, are those witnesses going to ride with Rocky, which is the head boss, the money, or are they going to ride with the other guy, or are they going to ride with the truth? And his name, the other guy, ASAP, really. I guess I'm saying that, really. Oh yeah, it said it grazed his hand. Yeah. So I can make this a little bigger for y'all real quick so we can know what the. Let me see. So real quick, okay, say. In October 21, a member of the group called ASAP Josh died. In a group text, his mother asked for financial help bringing his body back to New York. Okay. Step. Okay, so Rocky testified. Oh, Mayers. Mayers is Rocky. So Mayers, Rocky, was supposed to step in and say he would pay for it. So the friend Ephraim, it's easy to send their names. Really, ASAP really testified that Rocky stepped in and said he would pay for it, which is Rocky got the money. I mean, let's be for real. Really said Rocky said he'll pay for it. All this hearsay. Really said he believed Rocky never followed through. And he said, "You so effing fake, it's sad. Don't ever forget who introduced you to this life." This is him talking to Rocky. When I was at my lowest, you looked at me like I was a piece of ass. Really acknowledged learning that later that Rocky had in fact paid for the entire funeral. So he got mad, but then he acknowledged that he learned about it later on that Rocky did in fact pay for the entire funeral. So you was mad for nothing. A month after sending the text, really, ASAP really, aka Ephraim, was in the car with another member who went by ASL Barbary when Sheldon got a call from Rocky. Shelton put the call on speakerphone, and really, the person that was shot said he heard Rocky invite Sheldon to his performance. Shelton refused, telling Rocky to stop having your assistants hit me up. Out of nowhere, he recalled Rocky says, "F that N really." That's crazy. F that N really. Why would he just randomly say F that N really out of the blue and really was just sitting in the car? Rocky's talking to someone else, having a conversation about something completely different, and out of nowhere he says F that N really. Nah, really, you just want to be mad. It sound like you put yourself in it after overhearing the conversation. Okay. Really, ASAP really said he sent a message to one of Rocky's friends calling the rapper a vulgar name. So it's to me, you started it. You sent a message to Rocky calling him one of his friends calling him a vulgar name. The evening of November 6th, Relly was sleeping at the Hollywood Hotel, he woke up to see he missed calls from Rocky and two other members of ASAP. They probably like, hey, why are you talking about me? You telling people, you calling me a vulgar name. According to text messages shown in court, Rocky wrote to Relly asking, where you at? Short for work, where you at? Then let's get to it. Stop ducking my calls. Using FaceTime, really, the person that was shot called Rocky, aka Mayers, aka Rihanna's boyfriend, and told him falsely he was staying in the W Hotel. Rocky, who could see the room on FaceTime, said that's not the W, that's a bum hotel. So Rocky said that's not the W. Then Relly agreed to meet Rocky at the W. We were just going to link up, talk, he recalled, thinking there was a little bit of tension, so I thought there might be some roughing. Okay, so you knew it was going to be some roughing, but I thought we were going to walk away like brothers. Oh, so you were going to fight. You were going to fight. He said there was a little bit of tension, so I thought there might be some roughing, but I thought we were going to walk away like brothers after it was over with. All right, so let's keep going. Really, ASAP Relly walked down Hollywood Boulevard towards the hotel. Rocky was asking where he was, so I started jogging. Sorry, y'all, I've been reading all day. So I started jogging. So what you jogging for? Jogging mean y'all know how it goes. Somebody jogging like they getting ready to fight, they running up on you. He was on an avenue, he testified when he heard Rocky say, what now, P? Oh, at least y'all abbreviate the word P. They didn't do that in the court documents. He said he saw Rocky coming in hot. Rocky coming in hot, but you the one jogging. Okay, with two other people behind him. In a confrontation partially captured by surveillance cameras, Rocky grabbed him by the collar, Relly said. And then somebody tried to break it up. Then Relly testified Rocky pulled a handgun from his waistband and pressed it to his chest, stomach, and head. He pressed it out 3 different places. He placed it, and you stood there while he did it. He pressed it to his chest, stomach, and head. Relly said he told his one-time friend, shoot that shit. Why you brought a gun if you're not going to use it? Okay, so you talking all this bad stuff, shoot it while he's pointed at your chest, stomach, and head. Some people walk by. Rocky put the gun back in his waistband and started to walk away. Okay, so he walked away, according to the person that was shot. When he saw that Phillips was putting away a pocket knife, he said he felt betrayed. So I'm guessing this is Relly talking. Relly said when he saw Phillips putting away a pocket knife, he felt betrayed. Seeing red, this is the victim, y'all, the complaining witness. Seeing red, Relly followed Rocky and Phillips, a person who has a gun and a knife. He said he followed them, airing out ASAP's dirty laundry. He was letting him know how everybody feel because nobody's brave enough to say how they feel about this man. Relly brought up ASAP Yams, a founding member who died in 2015 of a drug overdose. He called Yolanda a crackhead and noted Phillips was living back in the projects. I felt this was my time to get everything off my chest. So you still antagonizing the man with the gun. Okay. As he followed, his word, as he followed them onto Selma Avenue, Rocky turned around and shot me. Ephraim testified he felt his hand get hot. And then I guess the lawyer showed a photograph of his left hand, the knuckles of several fingers, skin raw, not raw. Relly testified he grabbed Yolanda and used him as a shield. So the victim, the person that was shot, said he grabbed somebody else and used him as a shield. The lawyer asked, did you intentionally put him between you and the defendant, him and Rocky? And he said, yes. Oh, wow. This y'all finna be crazy. You can't make this up. ASAP Yams. Yeah, this is crazy work. Really, ASAP really was moving back and forth. Oh no, not Rocky. Rocky is Mayors. Rocky was moving back and forth. Really said trying to get a clean shot. After firing 3 or 4 shots in all, he testified the rapper ran off. About an hour later, um, Really returned to the scene and picked up 2 cases off the street. He sent Rocky a video of the cartridges writing, you try killing me. Wait a minute. So you done went back to the crime scene and picked up your own shell cases, your own bullets off the ground? With your hand, somebody said he went and punched some bricks. Trying to get a clean shot. He get a come on now. So he CSI. So he CSI now. He done went to the crime scene where he said his man was just shot. Okay, so he went back a whole hour later. He returned and picked him up off the street. He sent, and not only that, instead of calling the police or getting treatment, he sent a video to Rocky writing, you trying to kill me. And Rocky replied, Real, what the F you talking about? Why are you telling people I shot at you? After Really told Rocky he had tried to take me from my daughter, the rapper told him to stop making accusing Really of extortion. Rocky told him to call the police if I shot at you, you weirdo. Now that's right. That's what I'm saying. Somebody shot you, like Rocky told him, if I shot you, call the police. And look, 2 days after the shooting, here we go. 2 days after, Really walked into the Los Angeles Police Department, Hollywood Station, with his attorney and handed over the cases. Nah, bro. This ain't it. Measured and composed, when questioned by the attorney, Really demeanor changed when cross-examined by Rocky's attorney. And this was the attorney, Joe. He was the attorney that represented Trump in one of his cases. And Rocky's lawyer suggested Really made up the shooting to get money from his former friend, who he is now suing, by the way. You can't forget about that. He's suing him in civil court. He claimed Really lawyers asked Rocky's civil attorney for a monetary settlement a day after the rapper was arrested. So a day after Rocky was arrested, Really's lawyers went to Rocky's lawyers trying to get some money. They were requesting money to impact a criminal case or not impact a criminal case. The lawyer said, noting it was illegal to barter a criminal case away, even though it happened all the time. I bet you if Rocky would have wrote that check, we wouldn't be talking about this today. But he probably was asking for way too much money. And even though sometimes people pay money to settle a case, doesn't mean you're guilty. Sometimes it may be cheaper just to be done with it, make it go away, than going to trial and potentially losing millions. Rocky's lawyer asked Really if he sent a text to Rocky's manager that read, I'm getting itch. And Really said he meant to write, I'm getting irritated. and Rocky's lawyer said, you didn't mean I'm getting rich? Yeah, because rich is more close to irritated. They just making stuff up. The exchange grew heated. Really called Rocky's lawyer a tough guy. So now he mad at the lawyer. And that's good because the jury's going to see that same demeanor, that same energy you had with Rocky. And the jury will be like, okay, we see why he shot you. If it's true, allegedly. You all in the courtroom running your mouth. Okay. I'm just kidding. Yeah, don't hit the dislike button. Oh, he's advocating violence. Rocky's lawyer told Really, who had shown the lawyer his license to carry a gun in Florida, that he wasn't the one who kept guns in his waistband. Yeah. Really shot back what your client does. What does that even mean? So what is he saying? He shot back? Is he saying yeah? And he referring to himself in the third person? Yeah, everyone shot back what your client does. That is some interesting conversation. Oh, y'all. Guilty. Do we need to do a poll? Guilty or not guilty? We do a poll now, and then we can do another one as we watch the trial the first day, as we learn more evidence. Right now, I'm voting not guilty just because you did too much. You did too much. You caused it. You went to a place that you wasn't at, knowing that y'all were on bad terms. When you saw him, you started running up on him. You call it jogging. We know what that is. They run up on you, pulling their pants up. You went there for a confrontation. Not only that, after, in your own words, you said they were walking away. They were walking away, and you said you start seeing red, and you followed them. Let's see if I can find that. Let me see if I can find the word red. Right here. Seeing red. You said you followed them. Because and not only were you following them, you were airing out his dirty laundry. Yeah, you was following him talking noise and follow. We know you was following him, running up on him, still trying to fight. I mean, you just said he pulled a gun on you. Maybe you mad. Then you said you saw somebody else pull a knife. When you saw the other guy pull a knife, putting away a pocket knife, you felt betrayed. So then you followed both of them. The person you said had a gun and a knife. So you kind of like just stirred up this whole incident. Rocky didn't go out of his way. He didn't find you at your hotel, track you down, find which one you were staying in, walk in there and just shoot you. I say you have pocket knife. I say you have equal responsibility. And then you tamper with the crime scene, you tamper with the evidence. Instead of calling the police, you went back and got 2 random shell casings, and we can't even verify. I mean, I'm sure the police, there's no chain of custody, can say that those shell casings came from any gun that Rocky owned. You tamper with the evidence, which is obviously a crime. You didn't go to the hospital, and you showed up to the police station 2 days later showing pictures of your hand. Like somebody said, you could have punched a brick or anything in that time period. That's why you're supposed to report it right away to preserve the evidence. So like Mr. Bruce said, so you see a side now. Then he went and punched some bricks. And his lawyer probably told him, you better, before we get this settlement money, you better punch it good. Hell, why not? Why stop at punching one hand? Punch the other one too. He probably hit that first thing of bricks and it probably hurt. He said, oh, hell no, I ain't doing that no more. One hand is enough. Let me get off of here. Let me get off of here. This has been fun. It's been fun. So we gonna watch this trial, y'all. Ashley said he tried to set him up for money. Yeah. And even just to look at the other side of the coin, the day after Rocky went to jail, he had his attorneys reach out trying to get paid. So you wanted money. Even if it happened exactly how you said it happened, you wanted money and you tampered with the evidence. And that's why his lawyer is telling Rocky, you shouldn't be on, take a plea deal and be on felony probation or be a convicted felon because somebody says you did this when really they're looking for a payday. You're looking for a handout. Somebody said, why his name? Y'all know what? Y'all funny. I don't know. I don't know. Maybe it's an acronym. But yeah, when I first was reading it, and this, I'm just not reading this article with y'all. When I was skimming through, I was like, yeah. I said, wait, where this going? Where we going with this? Do I need to stop reading this sentence or what? But they said, no, that's somebody's name, a founder. What they say, was he a founder of the group or something? A founding, oh, he passed away. A founding member who 2000 of a drug overdose. So they saying that, so he's accusing Rocky of calling him a crackhead, and then noted that another member of ASAP's team was living back in the projects. So he said, I felt it was a time to get everything off my chest. I don't know. I don't think the jury will go for that. Oh, okay. She said, go back and look at the benefit concerts Rocky has for Yams every year. Very well respected. Right. And it almost sounds like this guy may be talking about stuff he don't know, because if he's having benefits and sports stuff for him every year, then it got to be some type of respect there, or what he did for the group when he was alive. He founded the group. Um, so just because you heard he called him a crackhead, or somebody said he called him a crackhead, just like you said, he didn't pay for the funeral or didn't fly the body back, and come to find out he did pay for it. That's why you stay, hey, let them handle that. If the mama reached out to Rocky to pay for the funeral and needed the money, then you let them handle that. Don't interject yourself into that conversation. Unless you're gonna be paying some money too. You helping? You helping? I mean, because you can't, just because ASAP got money, and he probably didn't have as much money as he has today, you can't be, he automatic, oh, you got to pay for this. You got to pay for that. You got to pay for drug treatment for this person. You got to move this person out the projects and buy them a house. You can't be responsible for all these different things for 100, 200 people, for grown men. I mean, I don't care how much money you got. You keep spending it, eventually the pile will get smaller and smaller. But yeah, this has been a crazy ride. Yeah, I think he mad. He probably didn't feel like he got what was owed to him. So, but I don't think he should have, did it this way. Yeah, I think he upset in his feelings. They go to him right now and say, we got 100,000. Really gonna come to court and have amnesia. He said, you know what? It's been so, he gonna come to court and do the Woody. It's been so long, man. This is 2020, 21. I don't know who shot me. The prosecutor might cuss out loud. Now, if he asking for $500,000, yeah, we're gonna have to pull some of that up throughout the trial. When we get breaks, then we can go in, and if you pop back in, remind me. We can watch it all together. Some of the stuff that the benefits. But I didn't want to do it now because I don't want to hold y'all. We're going on almost 4 hours. But I definitely appreciate y'all. Thank y'all for popping in and watching. And I think the trial, let me see the trial date. I hope the quality good, y'all, because I don't know. Sometimes y'all seen it. The camera don't be positioned right, the sound be bad, you don't know what's going on. Oh, January 21st. So that's Tuesday. Said he was known in Harlem. I'm gonna do some research when I get off of here. Oh yeah. Thank y'all. No problem. We get to see the lawyer Sly Kiss and Mary while talking. Well, we see why they're so close in the courtroom, because they don't get to talk to each other, in the jail no more. This is the only time they can get, so when a mama have a new baby, they had that skin to skin contact. Oh, the daddy, but oh man. All right, y'all, let's go. All right, thank y'all, and thank you again to the people that like and subscribe to the channel, and also to Miss Stephanie. That's really kind of you. I don't know if you're still here, but thank you so much for always supporting the channel. And let's get out of here. She's still laughing. y'all gonna be laughing all day. All right, y'all. Well, before I go, oh yeah, be safe the next few days with the weather. Yes, for sure. Hopefully y'all know how Texans do. They say we got our grids together, and and generators and all that stuff. So hopefully we can stream. But I think we should be good. I just came back from Colorado, and it was snowing. It was all in the mountains and stuff up there. So I know we'll be all right. He said, "How we don't?" All right, everybody have a great night. All right, before I go, let me give my legal disclaimer. He said, "We're gonna shut down." Right. Let me give my legal disclaimer. No legal advice intended. I'm a lawyer, but I'm not your lawyer. I'm just here to talk that law. Thank y'all so much for supporting the channel, and I will see y'all on the next one. Let's go.